May I please your
And my lord,
lordship?
When?
tomorrow, my lord.
Tomorrow, okay.
And my lord, one item, my lord, item number 1, my lord. Can it be taken up at 2, my lord?
Okay.
I am obliged.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 14, your lordship.
14.
14. Lordship, may I kindly.
You are
present
appearing for whom?
Mrs. A. Gain for the respondents, your lordship.
MS so-and-so, the learned counsel appearing on behalf of MS A. Gayan, the CGC, which is not with the consent of the others, with the consent of the other side, prays for adjournment of
Adjournment,
the
your
matter for
Adjournment, your lordship.
adjournment of the matter for 2 weeks. Let the matter be listed in the month of May. Yes.
Bail application, it was filed last Monday. My prayer will be taken on tomorrow.
Okay, tomorrow. Okay.
May I please, Lordship? Lordship, I beg to mention item number 15 and 16.
For listing, there is a senior.
Okay. Mr. Rasid, for new matters, I mean, there is a senior counsel, a senior judge is there. It was rejected earlier. Okay.
May I please, Lordship? Lordship, I beg to mention item number 15 and 16, Lordship. I have
15 and
already-
16.
Lordship, I have already informed the other side, Lordship. Let it come up after 2 weeks, Lordship.
Mr. So-and-so appearing for
Petitioner, Lordship.
petitioner,
Lordship.
appearing for the petitioner submits that submits with the consent of the other side for adjournment of the matter. Prays for, no, don't write submits, prays for adjournment of the matter. Let the matter be listed up in the month of May.
Lordship, interim to continue.
Interim order so passed earlier shall continue till the the date of listing.
Lordship, I have another prayer, Lordship, in respect of item number 32, my lord. Here I am appearing for the respondents, Lordship. I have already taken consent from the other side, Lordship. Lordship,
You are
let it also-
appearing for the respondent 32.
Lordship,
Mr. So-and-so, the council appearing for the respondent submits that with the consent of the other side, he prays for 2 weeks time, 2 weeks time. Let the matter be listed in the month of May.
But if there is an interim in this item,
Interim order so passed earlier shall continue till the next date of listing.
I'm deeply.
Lordship, I beg to mention item number 53 of the supplementary
Hmm?
list, Lordship. Item number 53 of the supplementary list.
Yes.
Lordship may not like to take up this matter. Lordship has appeared in
Oh,
for the
okay.
respondents, Lordship.
Let the matter be listed before an appropriate bench without me.
Obliged, Lordship.
May it please your lordship. Lordship, I beg to mention item number 46 from today's list.
46.
Yes, my lord. My lord, in this matter, my lord, the respondent number 1 has filed one affidavit.
Hmm.
666 has filed one affidavit, my lord, but the copy was not served to us. My lord.
Okay, you saw the
I am-
copy?
Lordship, the matter, the affidavit has not come on record only.
No, you saw a copy to him. He's a PR petitioner.
Yes, my lord.
The
Thereafter,
petitioner is to be served. Without serving, how can you file an affidavit? Okay, we are posting this matter after the vacation.
After we-
On the joint prayer of the council appearing for the parties, let the matter be listed after the vacation, after the ensuing due vacation. By the time you serve a copy to him,
May it please your lordship. I
Hmm.
beg to mention item number 19, lordship.
item number 19.
Yes, may I pray this matter may listed after vacation, lordship.
Okay, on the prayer of the learned council appearing for the petitioner, let the matter be listed after the ensuing due vacation.
Interim, if any may continue. Interim order passed if earlier may.
There is an interim order.
Yes.
Interim order so passed earlier shall continue till the next date of listing. Yes.
Please, your lordship. I beg to mention item number 17 of today's daily list
17.
for adjournment. The advocate concerned for the
You are appearing for whom?
S. Das Gupta on behalf of S. Das Gupta.
You have intimated the other
Yes, my
side?
lord, they intimated, they have.
Okay,
confirmed,
okay.
my lord. Can it be
Okay,
the-
our learned, MS so-and-so, the learned counsel appearing on behalf of the petitioner. With the consent of the other side, prays for adjournment of the matter for 2 weeks. Let the matter be listed let the matter be listed in the month of May.
Yes. Obliged.
May I please, your lordship, my lord, item number 39, my lord. That
Hmm?
matter may kindly be 39, my lord.
39.
13.
What happened there?
My lord, that matter will be taken after due vacation, my lord. I am for the petitioner, my lord.
On the prayer of the learned counsel for the petitioner, Let the matter be listed after the, in the month of May. Let the matter be listed in the month of May.
May it please your lordship. Your lordship, I beg to mention item number 41. Your lordship, my senior is currently out of station.
Who is the
Yes.
senior?
Dr. B.N. Gogoi.
Hmm?
Dr. B.N. Gogoi.
Item number?
Item number 41,
You are appearing for whom?
respondent.
Respondent.
Lordship.
Dr. B, who's?
B.N. Gogoi. B.N. Gogoi.
Okay. The learned, MS so-and-so, the learned counsel appearing on behalf of the respondent. You have intimated the
Yep.
other side?
Your lordship, there is no further your lordship, there is no further instruction. As
You are
from the
appearing for the
department.
petitioner? Okay. With the consent of the other side, matter may be listed, May. Okay. In the month of May.
May I please, Lordship, for listing one regular bail application. It was earlier rejected by your Lordship. Tomorrow.
Tomorrow it will be difficult. no? You have
he
filed it
said
already.
150 days.
You have already filed. What happened?
He is already behind bar more than 150 days.
Okay, tomorrow.
May I
Tomorrow,
please, Your Lordship? I beg to mention item number 20, 20.
22,
20, 20.
20, yes.
Yes, sir. I'm for the petition, Amala. I have taken consent from the other side.
Waiting for the respondent GMC.
I prefer pass over for the my senior as Botako is out of station.
Okay, Mr. So-and-so, the learned counsel appearing on behalf of Mr. S. Botako, the learned counsel for the petitioner. Praise for adjournment of the matter.
A. Botako.
And MSA Botako appearing for the opposite party. Does not object to the same, let the matter be listed. After the ensuing vacation.
Lord. Deeply obliged.
May I please your lordship? Lordship, I beg to mention item number 13,
Hmm.
and for the petitioner, your item may be taken up after vacation, your lordship.
You are there? Who is appearing at this?
I'm the respondent, Your Honor.
Item number 13.
13.
Affidavit was not tagged actually.
Yes, we have filed the affidavit, Lordship, day before yesterday.
It was not tagged with the record. Okay, okay.
The prayer of the learned counsel appearing for the respondent, right?
I'm appearing for the petitioner.
You are appearing for the petitioner, appearing for the petitioner, so means that an affidavit has already been filed by the respondents and you would like to file a reply to the same. Praise for 3 weeks' time, prayer is allowed, let the matter be listed in the month of May.
May it pleases my lord, I'm praying for some accommodation with respect to item number 30 of the daily list, my lord.
30,
30, my lord. I'm further praying for some time to file our affidavit in opposition, my lord.
just around.
In this case, 2-3 times they've taken time for filing a bill of opposition. And this honorable court pass an order that no coercive measures shall be taken against the petitioner. In the meantime, they are not filing the bill of opposition. And on the same subject matter, the authority have filed now FIR. For tax matter. Despite of the order passed by this honorable court, that no coercive measures shall be taken. They are not filing affidavit and for the tax matter, same violation. Now,
No coercive action, you are filing FIR.
They file FIR now.
My lord, but tomorrow we can file our affidavit, my lord.
No, reply is not submitted, but this honorable court has passed an order, no coercive measures shall be taken. And for violation of the tax matter, the same allegations, wherein this honorable court passed the order that no coercive measures shall be taken, now they are filing FIR.
You what to do, we'll have to take up the matter when? When can you file? And you'll have to, you'll have to answer this because if there is an order, standing order saying no coercive action, filing an FIR amounts to coercive action.
My lord.
On the same.
Filing an
subject
FIR, he has to take, he has to seek for a bail maybe, how can you
My
confine?
lord, but tomorrow we can file our.
matter. Filing affidavit will not do, tomorrow you will file affidavit, I will have to file reply. But how they can, do in this manner,
Okay, we'll take it up tomorrow, we'll see what is to be done. Tomorrow, will it be possible or day after tomorrow? You tell us.
My lord, but tomorrow, my lord.
Hmm?
We can file.
Tomorrow we'll list the matter.
My lord.
Hmm?
My lord.
Okay, you write on the prayer of the learned counsel appearing for the respondent. Let the matter be listed tomorrow. Tomorrow again, Dr. A. Saraf, the learned senior counsel is present for the petition. Tomorrow we'll take it.
Interim order till tomorrow, otherwise I don't know what they can do.
Interim order superstar earlier shall continue.
My lord, our instructions are voluminous, my lord. That's
No,
why.
interim order will be there. If there is any violation, then we'll see. So, but if, I mean, there is, there is a submission that there's an interim order, no coercive action. I don't know how you can file an FIR. You'll have to reply to that. Okay, we'll take it up tomorrow. We'll
So far,
see.
the excise matter, you know, she passed the order. So now the field order notification all have been withdrawn.
Which one?
That day, you know, she passed the interim order, my lord.
Ha.
The excise matter, my lord.
Correct, correct, correct.
All impugn notifications have been withdrawn.
Oh, withdrawn.
So I wanted to inform you.
Okay. Okay, we'll take it up tomorrow.
Yes. May it please, your lordship. Lordship, I beg to mention item 23 and 24.
23 and 24.
24, my lord.
Hmm?
Adjournment for a week.
23 and 24. Okay, Mr. M.R. Khandakar, the learned counsel appearing for the petitioner, prays for adjournment of the matter for 2 weeks. You are appearing?
No, no.
2 weeks. Full stop. Let the matter be listed in the month of May. In the month of May.
May. I'm.
Also, I beg to mention item number 42, your lordship.
For
Lordship, This
42.
matter become infructuous, so I may allow.
42.
Yes, lordship.
The learned counsel appearing for
Lordship may kindly record the appearance of my senior. We are appearing for R2, Lordship.
who is your senior?
Mrs. R.S. Chaudhary. Mrs. R.S. Chaudhary.
Arrestor is not there. Why should I record her her
I'm
presence?
appearing on
You
the-
are appearing. He is not appearing. Is he a senior counsel? Item number 42.
42.
On the prayer of, no, you are Mr.
Yes, I Akan.
S.I. Akan, S.I. Akan, the learned counsel appearing for the petitioner submits that on instructions, he would like to withdraw the instant case. Full stop. Prayer is allowed. Matter is dismissed as withdrawn.
So obliged.
Obliged, Lordship.
Your name?
Mr. D. Hazarika,
Mr. D. Hazarika is present for the respondent.
respondent number 2.
Okay, respondent number 2. It is already withdrawn. There is no.
Yes, yes,
Hmm.
Lordship.
Yes, give all the matters. These are all linked matters, I think. Item 2, 3, and 4 linked matters. Similar matters. Yes. Yeah.
Some of the matters, my lord, exactly linked, my lord. Had notice had already been issued, fixed tomorrow, my lord.
Hmm? Where, by which court? Which is the order? Show me the order.
Court number 10, my lord. The order.
There's a series fix at court 10, my lord, tomorrow.
Tomorrow at court 10.
Yes,
My lord, already listed.
Then why these matters were listed here?
You know, my lordship is also taking bench 5. My lord, Mrs. my lord, we can argue, my lord, but both the matters are telling, my lord.
Same challenge.
Same.
Listed before court 10
Listed.
tomorrow. Okay, the learned counsel. The learned counsel appearing for respective parties submit that the similar matter with similar prayer have already been listed in before another coordinate bench on 7th April. Full stop. Therefore, praise that these matters also to be listed before the same bench. Let the matter be listed before the appropriate bench. On 7th.
Right.
Is there any interim order passed there?
Interim order is not there, my lord. Obliged.
Okay, I can't be-
Wait, Mr. Lordship. Respondent was supposed to obtain instructions, my lord, here.
Hmm?
Respondents were supposed to obtain instructions.
Yes. Respondents, who is appearing?
Yeah, GST is there.
Well, it is a covered matter, my lord. Proximate after some.
So we pass it over for a time being. Six also, I mean, council. Mr. Borua, Gogoi,
The inspection is evident, I sought for it. Can it be, my lord,
it's a covered matter,
other,
Mr.
well, let it be on Wednesday, my lord. Day after tomorrow. Yes, I understand, but I've conveyed to them about the order.
Earlier, when the Assam Board of Appeal passed the order, the matter is being heard. They are not, my lord, this is only that they can, after this, they can hear with the revision application on merits. There's nothing.
Just, my lord, the written instruction, I've conveyed to the, my lord, joint commissioner. Probably, my lord, it will be, I will receive it today itself by evening.
I mean, no point pending this, Mr. Borua, Mr. Gogoi. Is there any point?
Yes, then, my lord,
There is.
But, and you have this, I mean, say that there is but Mr. Saraf, there is a small difference there in the case of Supreme Court. Supreme Court, I mean, there was an undertaking given.
So undertaking, I will tell you, no? If I give an undertaking, it will be ultimately finally heard only. So there is no question of undertaking because the undertaking what, my lord, 25% I've been directed to deposit. Now the revision will be finally heard. Either it will decide against me or in favor of me. So the undertaking for the purpose of 25% does not arise. And Assam Board of Appeal directly directed 25%. Unnecessarily kept pending. For them, it is loss.
We'll dispose it. I mean, say the Supreme Court has said, I mean, for PA,
the Supreme Court as
for
well as-
PSUs, government undertakings, they have given some kind of.
No, specially to the writ petitioner itself.
Yes, yes.
First petition. So he has, I think Mr. Saraf has three cases, I think. So
Three
today,
cases, yes, 3 cases.
three applications, right?
It can dispose, they can hear the revision.
Yes.
application.
No, we'll dispose it up. I'll pass the order. I mean, I'm not passing
Yes,
it here.
Lord,
We'll,
so, my lord,
I'll-
item numbers are 6, 9 and 52.
6, 9 and 52.
Yes.
There'll be a short order. I'll pass it and I'll allow it, and let the.
Because that order was passed in favor of the petitioner only. my lord.
On the.
Yes, so on that basis, otherwise, my lord, all PSUs will come up with the same thing.
Let them come, but like, there's a
Here,
different
my
thing.
lord, they've got a, my lord, earlier order of the Honorable Supreme Court.
Otherwise,
Yeah.
at least.
So,
Mr. Gogoi should not restrict the Melonas to file the petition.
yeah, I'll pass an order. I mean, I'm not dictating here, it will consume time.
And,
I'll pass
Can
it.
we admit it and proceed for the hearing of it.
Yeah, we will just say that this is covered. And another thing is that like, so, I mean, the Supreme Court is specifically
So the revision
stated.
application may be admitted as passed, no,
Huh?
without, revision applications may be admitted without payment of the
No,
decision.
no, correct. That will be there. That will
I'm
be.
highly obliged.
That will be. So 6, 9 and 52, you record, Mr. Dr. Saraf and B. Gogoi, yeah? B. Gogoi, additional, Dr. Saraf, assisted by B. Sharma. I'll pass down.
Right.
The other, another matter, Mr. B. Gogoi, you were there.
I've got the parawise comment, I will like to file my affidavit.
This item number, 5.
I've got the instruction, I will file my affidavit. I've got the instruction. Parawise-
Is it not covered?
Well, let me file my, they've given a detail of parawise.
Yeah.
Yes, I will file it.
Okay, Mr. Heard Mr. R.S. Mishra, the learned counsel for the petitioner, also heard Mr. B. Gogoi, the learned additional advocate general appearing for the state respondents. Mr. Gogoi submits that he has received the instruction and would like to file an affidavit in the instant case. He prays for 2 weeks' time. Prayer is allowed. Let the matter be listed after the ensuing due vacation.
Mine.
This is interim order, my lord.
Interim order so passed earlier shall continue till the next date of listing.
Okay.
May it please your lordship. Here, my lord, so far by issued, my lord. For 3 components, my lord. One is for violation of section 16(4), my lord. Section 16(4) restricts, my lord, for claiming input tax credit, my lord. Subsequently, my lord, section 16(5) was inserted, my lord. And then subsequently, my lord, after passing.
So you have been issued what? DRC? OA?
So called, my lord, page 737, my lord.
Yes.
In the so cause, my lord, there were three issues were raised, my lord. Lordship will see point number 2, my lord, excess ITC for.
So we'll issue notice on this.
It can be disposed of because, my lord, similar matters have been disposed of, my lord.
Hmm.
Yeah, my lord,
Please, give me the order where, what is your case exactly?
My lord, after the subsequent amendment of section 16, my lord.
So,
section
so that has been implemented retrospectively.
retrospectively, therefore,
So this is, I mean, now this will not be, this will not be applicable to you.
yes, my lord. Only, my lord, I have to, there are 3 components. I will require to point 2 components, my lord. Rest is covered, my lord, by amendment, my lord.
Lordship, subject to the payment of the excess amount, your lordship,
Yes,
the
yes,
matter
my
may
lord.
be disposed of.
Lordship, will see page 37, my lord.
The same case, similar case.
Similar case, but there is one distinction is there, my lord. Here, my lord, I am required to pay certain amount, my lord. That I am showing at page 37, my lord.
Page 37,
37, my lord.
where,
Paragraph number 2, my lord. It's amount, my lord, 10,214, my lord.
page number
Page number 37, my lord.
37, yes.
And paragraph number 2, my lord.
Paragraph number 2, excess utilized.
Yes, this 10,214, my lord.
Ah,
That I will be able to pay, my lord.
hmm,
And then, my paragraph number 3, my lord.
hmm.
Rupees 553, my lord.
That is excess amount, that will have to pay.
That paragraph number 4, my lord.
Hmm,
That is my excess ITC, my lord.
hmm.
That I'm not required to pay in view of the amendment, my lord.
So 238 you need not pay.
Yes, my lord, I did not pay, my lord.
So you need to pay only 10,000 and 353,
553, my lord.
553.
My lord. This 2,38,000 will be covered by this order which I have relied, my lord.
And which is the notification?
It is an amendment in section 16. my lord.
Amendment in section 16. So amendment is, I mean, the same amendment, right?
Yes, my lord.
Section 16(4).
16.4 was, there was restriction. Now section 16.5 was inserted, my lord.
So provision of section 5 and 6 inserted.
Yes, my lord. And section 5, a provision of section 5 says, my lord, the returns which have been filed up to 30th of November 2021
Hmm.
will be eligible for taking input tax credit for the financial year 18-19, 19-20, 2021. In this present case, my lord, financial year involved is 18-19.
1819.
18-19, the financial year involved.
Hmm.
My returns were filed, my lord. I've given paragraph number. My lord, paragraph 4, my lord, returns were filed on 26/8/2020, my lord.
Okay, heard Mr.
R.S. Mr. Man.
R.S. Mishra, the learned counsel appearing for the petitioner, also heard
P. Upadhyay, your
P.
lordship.
Upadhyay,
On
the
behalf of Mr. S.C. Kyal.
P. Upadhyay, the learned counsel, on behalf of Mr. S.C. Kayal, the learned standing counsel, Central Goods and Services Tax Department, full stop. The petitioner in the instant case has challenged the demand cum so cause notice dated 20/10/2023. Why have you come so late?
My lord, after passing of this order, my amendment was.
Amendment only, but it was pending from 20/10/2023.
It was, the order was passed on 7/2024, my lord. The lordship will find it page 45.
7.2024.
Order was passed, my lord.
Hmm.
The amendment, my petitioner was in the impression, my lord, that it will be.
Okay,
rectified.
so cause notice dated 20/10/2023 issued by the respondent number 4, alleging that during the financial year 2018 2018-19, the petitioner has availed input tax credit amounting to 2,38,928, which was in violation of section 4 of CGST Act 2017. As the aforesaid ITC was availed beyond the time limit prescribed by section 16(4), full stop. Pursuant to the aforesaid so cause notice, the respondent number 4 passed the order in original dated 7/2/2024, confirming the demand of rupees 2,49,142, along with interest of rupees 553 and penalty of rupees 24,914. Full stop. Next para, right? It is the case of the petitioner that subsequent to the passing of the aforesaid order in original dated 7/2/2024, the subsection 5 and 6 have been inserted in section 16, whereby the time limit for availing ITC for the year 2017, for the financial, for the financial year 2017-2018, 2018-2019 and 2019-2020 was extended up to the 30th day of November 2021. In view of the aforesaid amendment to section 16, the petitioner submits that in view of the aforesaid amendment, it is the case of the petitioner that in view of the extension of the time limit till 30th November 2021, the petitioner is not required to pay the demand of rupees 2,38,928, right? Full stop. It may be relevant at this stage to refer to the section 16 pre-amendment as well as post-amendment, and the same is extracted here in below. You write section 16(4). You can take it from here, no? Section 16(4) from you can take it from here. Then amendment comes, para 4 and para 6. You can take it from here. Next para. In view of the aforesaid amendment, it is seen that the time limit has been notwithstanding anything contained in section 16(4) of the CGST Act, 2017, in respect of any invoice or debit note for supply of goods or services, or both pertaining to financial years 2017-2018, 2018-2019, 2019-2020. That's all, no? And 2020-2021. A registered person shall be entitled to take tax input and take input tax credit in bracket ITC in any return under section 39, and the same can be filed up to 30th November 2021, correct?
My lord.
Next, in view of the aforesaid amendment, it is seen that the challenge in the instant petition need not be addressed at this stage in view of the amendments, in view of the aforesaid amendments, full stop. Yeah, same paragraph. In view of the amendments brought in, it is evident that the petitioner herein, is entitled to avail the benefit of input tax credit for the relevant period, full stop. MS so and so, the learned counsel appearing on behalf of the CGST submits that the instant application can be disposed of by payment of
It's 37 million.
Annexure D, your lordship, page 37.
payment of rupees 10,214, which is excess utilized amount, and an amount of rupees 553, which is interest on cash amount. Full stop. Full stop. To the submission made by the learned counsel for the CGST, the learned counsel appearing for the petitioner submits that he doesn't have any issue in payment of the aforesaid two amounts, and therefore, the instant petition is disposed of with a direction to the petitioner to pay the aforesaid two amounts, within a period of 30 days.
My lord.
Within a period of 30 days. Within a period of 30 days, and on such payment, the CGST shall withdraw. CGST shall withdraw the demand notice. Huh? CGST shall withdraw the aforesaid impugned demand notice. I mean, is there any requirement of issuing fresh notice?
No, my lord, since I'm admitting the liability,
Huh?
the liability I'm admitting which are required to pay, my lord.
Correct.
They are accepting the penalty that has to be.
So, I mean, you can withdraw the demand notice,
That we get.
or we should set aside this.
Can set aside.
Hmm?
With the direction to pay the interest and the.
You right, with the direction to pay the amount within 30 days, and be in view of the aforesaid direction, the demand notice dated 7/2/2024 to 7 demand notice name. What was that?
Order in original.
Order in original dated 7/2/2024 is set aside.
Much.
In view of the aforesaid directions, the instant petition is disposed of.
Much.
Yeah, let's. The petitioner is not accused. Against the impugned order dated 70/2026, whereby my license has been cancelled.
You don't have any case, Mr. Khanikar.
Or without issuing any notice.
No, you are not complying with this. I mean, how
I
can
have
you?
complained, madam.
No, how can you, I mean, you have been given a notice for a particular space and you keep on changing your
Well, kindly have
places.
municipal board.
No, I have gone through everything.
No, my lord, the license, my lord. You also will kindly see my lord, license, my lord.
You would like to respond to this?
My lord,
Actually, the municipal board is the main party. Even then, Malat, I'll take instruction, ma'am.
Okay, I mean, heard Mr. A. Khanikar, the learned counsel appearing for the petitioner. Also heard Mr. M.S. Udas, the learned counsel appearing for all the respondents.
I'm for you, Das, Malat, for 1, 3 and 4, Malat.
1, 3 and 4. 1, 3 and 4. Anybody appearing for CDPO? CDPO, somebody is there?
Project, Malat, but otherwise a project, so that's why I'm not taking up Malat. Child development.
Okay, so and so, then you write, then you write, a petitioner has challenged the impugned order dated 7/3/2026. Petitioners have challenged the impugned order dated 7/3/2026 passed by the Abhayapuri Municipal Board, cancelling the NOC. NOC dated
10/12, my lord.
Huh?
25. 10/12/2025.
10/12/2025.
25, my lord. Annex C.
Issued to the petitioners for operating a rehabilitation center, rehabilitation center. Full stop. Let notice be issued, returnable in 4 weeks. Notice, since MS UDAS has represented respondent number 1, 3 and 4. 1, 3 and 4, no formal notice is required to be sent. Steps for notice to respondent number
2 and 5.
2 and 5. 2 and 5 to be taken within 3 days by speed post as well as in usual course. Full stop. Let the matter be listed after the BUBK, in the month of May.
Diplo.
My obligation. My lord, kindly see the page number 30 and XR 6.
So somebody has to appear in this case. I mean, somebody has to appear. I mean, no notice will go, can't do anything at this stage. Read, heard, Mr.
S. Rahman. S. Rahman.
S. Rahman, the learned counsel appearing for the petitioner. Anybody is appearing for
Banks.
bank and any other party is there?
No. Bank.
Or bank only?
S. number 3 is the bank manager.
So it's which bank is this?
Punjab and Sindh Bank.
Punjab and Sindh Bank, okay.
My lord, matter is the simple matter, my lord.
The simple matter, but we'll have to see, I mean, why your account has been freezed? I mean, if
Just,
you are only saying that some.
That amount is credited in my account from unknown person. I several
No,
times visit the
understand, but
branch manager.
understand, but whether it can be disposed of today?
Yes.
Now,
Yes, disposal may be disposal.
how?
If that dispute amount may be,
Some amount
Yes.
has come to your account.
I several times.
No, some amount has come to your account. You have represented before the bank. Bank is not doing anything. Bank must be having some reasons. Without hearing the bank, how can I order to defreeze your account?
My lord, that dispute
Don't argue
amount-
these kind of things.
Otherwise, my lord, the half account, my lord,
right.
my lord, it's difficult to run the.
I understand your problem,
Yes,
but thing is
yes,
that
ma'am.
we'll have to hear the bank. What is the,
Available, my lord.
what
In
is the
that-
bank,
in
the
account,
bank's
my lord, that also be closed.
We
This is
understand,
December.
we understand that you are having an unfortunate problem, but
Yes.
thing is that without hearing the other side, this cannot be disposed of.
Possible, my
Had
lord.
it been possible, we could have done it. But so and so,
My lord, please
you
justice.
right? No, first day, no justice service. I heard so and so. The instant petition has been filed by the petitioner. Petitioner to, with a prayer to defreeze his account, which has been freezed by the respondent bank authorities. And due to the fact that an amount of rupees 5,50,000 has been deposited in the CC account of the petitioner, that is right, CC account number 138016000000132. Full stop. It is the case of the petitioner that petitioner does not have any knowledge as how the money has been credited to his account from some unknown bank account. Full stop. In view of the aforesaid, he has approached the bank many times and submitted representation, but however, the bank has not done any has not taken any step to defreeze his account. Defreeze his account. Full stop. Let notice be issued, returnable in 4 weeks by speed post as well as in usual course. Steps for notice shall be taken by the council appearing for the petitioner within a period of 3 days. Let the matter be listed in the month of May.
Oblige.
And lordship petitioners.
Land in Assam can be transferred by way of power of attorney.
No, lordship. So he is lordship cannot transfer, but he, by way of power of attorney, he was empowered, the petitioner's husband was empowered lordship to transfer.
Your only claim is that, I mean, by power of attorney, it has been given to you.
Lordship, by power of attorney, the petitioner's number one's husband was empowered to transfer the land. And before his death, lordship, he, lordship, gifted the land to the petitioner's lordship. And after executing, before executing lordship, the deed lordship, he was aware, but the possession was there lordship with the petitioner's lordship. But my lordship, grievance is that lordship, out of the total land lordship, 3 quarters lordship was evicted by the lordship, Lord Pandit and the Gauhati lordship. illegally, Lordship. That is my Lordship, simple Lordship there, Lordship. And I have submitted representation to the circle officer, Lordship. This is also Lordship pending, Lordship.
So circle
There-
officer is not doing anything.
My
Why?
lord, it's a case of either a land grabbing or it might come under the civil suit, my lord, seeking a declaration and recovery of the land, my lord. Otherwise, my lord, this writ petition in itself is.
Not maintainable.
Yes, my lord.
Lordship,
This is not.
They are,
at least Lordship.
the land has not been transferred to any registered deed, my lord.
Hmm.
Their allegation is.
Only,
that-
only thing was that one power of attorney was
Yes,
there.
yes, only possessor.
Uh-huh.
And it has been evicted by the third party.
Third
So how
party.
come, my lord, writ petition is maintainable, my lord?
Lordship,
It will come under,
not third party, Lordship. it-
otherwise, my lord, this court will not cannot pass any effective orders.
Lordship, because he was not evicted, the petitioners were evicted by the government authority, Lordship. Government authority, Lordship. The Latmandal and the Gauhati, Lordship.
No,
Not-
whatever, I mean, your land is not as yet transferred to you. Even though only the possessory right was there and like
Yes.
there was some issue and dispute and you have been evicted.
And therefore, Lordship, the petitioner submitted representation. Kindly this, at least the circle officer may entertain my representation, Lord.
You entertain his representation.
Yes, Lord.
Yes, yes.
Will dispose it of
Yes,
in that
It-
terms.
Time frame, my lord, to
Yes.
dispose the representation. My only prayer will be, my lord, since it's a election time, so time little bit.
Sometime, 2 months
Lordship,
time.
Lordship. Page 24 is the representation, Lordship, first representation. That may be disposed.
Okay, heard Mr.
AMS Mayam.
AMS Majumdar, the learned counsel appearing for the petitioner. Petitioners.
And thus,
and
thus
and
two,
thus-
three, four,
234,
government advocate.
the government advocate for 234, MS G Hazarika for respondent number 1. The instant petition has been for, the case of the petitioner is that respondent numbers 4 and 5 evicted the petitioners from the land measuring 3 kathas out of the land measuring 1 bigha 15 lesser covered by DAG number 497, patta numbers 168 situated at village Khatuamari in bracket KA, K in bracket complete, the post office and police station Goalpara, revenue circle Balijana, Balijana, Moja Balijana, district Goalpara, Assam, by destroying their dwelling house and trees standing on the same land illegally without following the due process of law, and thereafter handed over the possession of the land to private respondent number 7 in collaboration with other private respondents for their unlawful gain and interest. Full stop. The learned counsel appearing for the petitioner submits that the possession of the land was gained by the petitioners petitioners
Page number 1.
in view of a power of attorney issued by the sister of the
Respondent number 6, Lord.
by respondent number 6, and thereafter the petitioners have been staying in the aforesaid land without any disturbance. Full stop. He submits that out of that land, he submits that land was in due for registration, but in the meantime, the
Petitioner,
respondent number 4 in collusion with respondent number 7 have dislodged them from the aforesaid land. Full stop. In view of the aforesaid action, in view of the aforesaid arbitrary action, the petitioners have approached the circle officer by submitting representations,
on 2010,
representation on 28/10/2025, which was not responded by the circle officer. And thereafter, they filed another representation on 17/11/2025. The same also had to face the same fate. Full stop. In view of the aforesaid, the learned counsel appearing for the petitioner submit that the circle officer should be directed cycle officer should be directed to respond to their, directed to consider their representation and accordingly dispose of the representation, full stop. To the aforesaid submission, the learned counsel appearing for the respondents do not have any objection. In view of the aforesaid, the instant applicable petition is disposed of with direction to the respondent number,
Circle officer is respondent number 3, Lordship.
respondent number?
3.
Respondent number 3, to dispose of the pending representation dated 17/11/2025. Before him, na?
Before
Before him, within a period of, period of 2 months from receipt of the certified copy of the instant order, full stop. In view of the aforesaid direction, the instant petition is disposed of.
My lord, this, the order of this honorable court will be served by him. My lord.
No, that's I've written the on receipt or a certified copy. Okay, you write one line. The petitioner shall submit the certified copy of the instant order at the earliest before the concerned respondent.
Right.
Before the concerned respondent number?
3.
3, respondent number 3.
Right.
Well, what's the remedy?
My lord, that last matter.
Yes.
Decision. My lord, today.
So we are hearing on merit now.
Yes, your lordship.
My lord, one thing.
Or it will take some time, we'll take it up after some time then, I mean, other matters are there, it will take some
My
time.
lord, that can be done.
We'll take it up at 2, because it will take some hearing, I mean, let me finish some other matters.
My lord.
If you do not have any problems,
No, no, it's all right. It's all right.
2 o'clock we'll take it.
Better. Obliged, my lord.
Or your lordship can do it as soon as the list gets complete in that case also.
List will take some time because
Okay.
it's a long list, I can see. Let's see at 2, if
Yes.
not possible, then we'll take it up.
Yes, sir. Deeply obliged.
Due to the one.
Which?
Item 18, my lord.
1 second, 1 second. 18,
Lordship.
okay. Some time for affidavit.
It's my lord, for instruction also, ensuing assembly election and all of it.
Okay, heard Mr. D. Saraf, the learned counsel appearing for the petitioner, also heard Mr. N. Das, the learned government advocate appearing for respondent number 2 and 3.
Right.
Respondent number 2 and 3. Mr. N. Das submits that he is yet to receive the instructions.
2,
And-
3, 4, my lord.
2, 3 and 4. 2, 3 and 4. He is yet to receive the instructions and prays for 4 weeks time. 4 weeks time, full stop. Prayer is allowed. Let the matter be listed in the month of May.
Obliged, lordship.
May I please, your lordship. Lordship, initially, the petitioner approached this honorable court for acquisition of his land without following any procedure of law, lordship. Thereafter, this honorable court, after going through the records, lordship, passed an order, lordship, of this, in this case, lordship, order dated 13/8/2025, lordship, may I kindly see. Where it was directed to pay compensation to the petitioner as there wasn't any acquisition process,
Hmm.
lordship. Thereafter, the government came with an IA, lordship, for vacating that stay, saying that now we are not doing anything and the process has already been stopped. And from the petitioner's side also, lordship,
So land is not acquired as yet,
they started
the process.
process, lordship. So
Hmm.
petitioner approved this honorable court. Then, lordship, this honorable court.
Now they have stated that they are not doing anything.
Now they are saying they have not, in the meantime, they have stopped, lordship, and from the petitioner also, I came to know that, yes, they stopped the process.
So what survives in this matter now?
No, nothing has been, but nothing is there, lordship.
So nothing is there, I mean, we'll dispose it of.
Lordship, but if they want to.
If they start any process, they will have to follow the process.
Yes,
They will-
that-
That they will do. I mean,
that
if they,
they lordship.
that if they do not do it, you have all the right to do it. I mean, how can we presume that like they will not follow the law?
They started lordship, that's why
No,
petitioner.
correct.
came
I
to
mean,
some-
now since they are saying that there is no process, right?
Lordship.
No process.
Lordship, and
So-
petitioner is also saying that in the
Petition becomes infractious, Lordship.
Yes.
petitioner is also.
Should I mention all those things or like simply we say,
Lordship, otherwise-
simply we say if a matter has become infractious?
No, lordship, otherwise if they starts again,
If you start again, Lordship, without following the due procedure, all this court is always open.
You're always there. I mean, how can this court will presume that
Lordship,
they
yes.
will start the process without following the law?
lordship, how it
Now,
is.
MS Kanungo, you tell me one thing, can the court presume that some action will be taken by the government without following the law?
No, lordship.
Last time, no, last time,
Lordship.
I mean, there was some allegation that it was not followed. So it came before the court. Now it is found out that like there is no process.
Now, why it has become infractions, that much may be mentioned.
No, infractions because there is no process started by them.
Yes.
No,
That
they
is the
have stopped.
statement.
They have started, lordship, they have stopped in the meantime during the process, during the pendency of this writ petition.
If your Lordship takes the affidavit filed by us, by the respondent number 3.
Affidavit or this IA?
No, Lordship, affidavit is same, Lordship,
Affidavit
Status.
in the writ petition?
in the writ petition.
Yes,
As because your Lordship is going to dispose of this matter, that is why I am relying on this. affidavit.
yes.
Respondent number 3, Lordship may come to page number 54, this vernacular one.
54.
Yes. May
Yes.
I read, Lordship?
Yes.
উপৰোক্ত বিষয় ও প্ৰসংগ সন্দৰ্ভত আপোনাক সন্মান সহকাৰে জনোৱা যায় যে ভূমিলেখ্য সহায়কৰ সৰজমিন প্ৰতিবেদন মৰ্মে পূব বৰক্ষেত্ৰী মৌজাৰ লোহাৰঘাট গাঁৱৰ সোয়েনছো মেডিপট্টাৰ ইমান নম্বৰ দাগত এজমালি পট্টাদাৰ হিচাপে মকছাদ আলী সোয়েনছো নামজাৰি চলি আছে। উক্ত দাগৰ দক্ষিণ দিশে মেপত চৰকাৰী ৰাস্তা আছে, আনহাতে উক্ত দাগৰ ওপৰেৰে কেঁচা ৰাস্তা হিচাপে মানুহে ব্যৱহাৰ কৰি থকা যায়। ইয়াত উল্লেখ থাকে যে উক্ত জমিৰ ওপৰেৰে প্ৰথমে PWD বিভাগে ৰাস্তা বনোৱা আৰম্ভ কৰিছিল যদিও পিছত পট্টাদাৰ মকছেদ আলীয়ে মহামান্য আদালতত গোচৰ পঞ্জীয়ন কৰাৰ বাবে উক্ত জমিত ৰাস্তা বনোৱা কামটো স্থগিত ৰাখে। উক্ত দাগৰ দক্ষিণ দিশে মেপত থকা চৰকাৰী ৰাস্তাত এতিয়াও PWD বিভাগে ৰাস্তা বনোৱা দেখা নাযায়। So, Lordship, that road was used by the people of the villagers. The villagers used that road. So accordingly, they most probably the PWD thought it was a PWD road. Accordingly, some materials were dumped there. When they approached this honorable court, they took it away, Lordship, and that process is stopped.
No, lordship, lordship may kindly see page number 39, my additional affidavit, by which I brought.
No, that is correct. But now they
Nothing
have
has
come up
that-
because there is no road going through
Yes.
your this thing now.
Now, lordship,
Presently.
presently they have
Present
stopped,
nothing. But if you find some kind of activities, then you can
then
always come.
again I will have to come.
You'll have to come.
But
There is
why
no
it
other-
has become infractions, that may be
See, I mean, from the communication, it is very clear
lordship.
that there may be some kind of miscommunication,
Yes.
nothing else. There was no proposal to take over your land.
Lordship may kindly see page number
Where?
39, where
39,
they have
okay.
admitted, lordship.
39, what is there?
Page number 39, my additional affidavit, lordship.
That I have annexed in my.
I think both, lordship may kindly go through that.
No, it will be easier if your Lordship takes the
IA?
affidavit. This same letter I have annexed that.
In the IA?
No, Lordship, in the affidavit also.
No, he's saying some,
No,
in the,
this is additional affidavit. On
Uh-huh.
that basis, this order was passed.
where, page?
Affidavit.
No,
may
one
be
second,
pending.
which page, Mr. Sarma?
Page 46.
46. Same letter, no?
Same letter, same letter.
Where they have admitted that there was.
One second, with reference to the subject cited above, I have to honor to inform you that as part of order of Gauhati connection. So the undersigned has demarcated the land of the petitioner, Mohammad Maqsad Ali, village, and found that the following land have been used for the purpose of construction of road without preceded by any acquisition proceedings.
So Pursuant to this letter, the order was passed. Next page.
Mm.
Next
Sorry.
page.
Lordship passed an order,
That is why I have preferred this IA.
then they stopped the
এটা এটাকে কওঁ
entire-
নেকি? এটা এটাকে কওঁ।
নাই, মই কৈ আছো ন, আপুনি ক'লে মাজত।
Okay, I mean, that is fine. I mean, there was some, maybe some, I mean, the miscommunication, there was some proposal. Now they have dropped it.
Yes.
They have admitted it.
So because of that, we have preferred that IA for modification, alteration of that order. Along with that, we have also filed the.
Modification of which order? This order?
Yes, Lordship.
This, 13.8,
Yes,
13.8/2025.
yes. As because in this order, there was a direction.
Hmm.
Paragraph, sorry, page 49, paragraph 2. Because of that letter, in view of the admissions made in the matter by the respondent, this court directed the Deputy Commissioner Nalbari to compute the compensation that now be required to be disbursed. So accordingly, Lordship, the joint verification was done. That is the next page, page 50.
The
And
joint
vernacular
verification-
one is page 51.
The joint verification was done, then after that, this order was
But
passed.
this is, yes, Lordship. So it is stopped. The PWD is not going to construct it with as of now. If your losses come to page 55,
Hmm.
your lordship will see the two persons riding with bicycle.
Hmm.
This is the Kacha Road, Lordship. It is made by the villagers. So this link,
Hmm.
the villagers make it for their own convenience, Lordship, to connect the two roads.
Hmm. Okay, we dispose it of. I mean, we heard Mr. M.S.M. Kanungo,
Yes.
S. Kanungo, the learned counsel appearing for the petitioner. Also heard Mr. H. Sharma, the learned additional senior government advocate appearing for respondent number
3 and 4.
3 and 4.
6 and 7.
M.S. E. Sharma for 6 and 7. M.S. For 1 and 2. 1 and 2. The instant read petition has been filed by the petitioner. Praying for compensation in lieu of the land acquired by the respondent authorities from the Kiraz Myadi Patta land of the petitioner, measuring 1 katha, 3 lasses under Patta number 220 and Dag number 716 of village Loharkath, Moja, Pub Borkhetri, PS Mukalmoa in the district of Nalbari. Full stop. Next para, the case of the petitioner is that the petitioner is the owner of of a plot of land in village Loharkatha under Pub Borkhetri Moja and Borkhetri Revenue Circle in the district of Nalbari, measuring 2 kothas. See, one place you are saying your land is 1 katha,
1 katha, 3 lessons, lordship.
huh? 1 katha,
Out-
3 lesser, 1 katha, 3 lesser, but one place you are saying it
No,
is 2 kathas.
Out of 2 kathas, 11 lessons, they acquired 1 katha, 3 lessons, lordship. Page number 6, my repeat petition, para 3, it specifically stated that, lordship.
Okay, measuring 2 kathas, 11 lessers under DAG number 716 of Patta number 220. It is contended that the respondent authorities, without giving him any notice, started construction of a road throughout the above mentioned Hiras Meadi Patta land, covering 1 katha 3 lessers out of the aforesaid 2 kathas 11 lessers under DAG number 716. Full stop. It is the case of the petitioner that the aforesaid land was acquired by the respondent authorities without following the due process under the Land Acquisition Act and other relevant laws. Full stop. Faced with the aforesaid situation, the petitioner has approached this court for payment of compensation if the land is acquired by the respondent authorities for construction of a public road. Full stop. Affidavits have been exchanged in the instant case. Next para. A coordinate bench of this court, while hearing the matter on 13/8/2025, passed a direction to the effect that the respondent authorities, especially the Deputy Commissioner Nalbari, to compute the compensation which is required to be disbursed to the petitioner and place the same before the Secretary stroke Public Works Department for release of the funds. Full stop. After the passing of the order, passing of the aforesaid order, the circle officer, Borkhetri Revenue Circle, Narayanpur, Mukalmua, vide a communication dated 1/9/2025 to the Additional District Commissioner Nalbari, intimated that a joint spot verification with the Public Works Road Department had been carried out, and during the joint verification, it was found that in fact, the people of the villages had been using using some portion of the land of the petitioner as 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 a road, and there is no construction of PWD road is or no was going on in the aforesaid land. Now, in the land of the petitioner under DAG number 716, patta number 220. Full stop. Subsequently, another letter dated 9/12
Page 52.
Hmm?
Page 52 of my application.
Yes. Subsequently, another letter dated 9/12/2025 was issued by the circle officer, issued by the same circle officer,
Yes, sir. Yes.
aforesaid circle officer, intimating the additional district commissioner Nalbari that after the joint verification, it was found that as per the map, a government road.
Lordship, page number 52, it is mentioned, Lordship. Initially, they commence.
Correct, but we are writing that only. As per the map, a government road existed. A government road exists on the southern side of the aforesaid DAG of the petitioner, full stop. It was also mentioned that a portion of the aforesaid DAG is being used by the public as an Artin village road. It was also mentioned that PW department had initially commenced construction of a road over the said land, however, the work was subsequently stopped and till date, no road construction by the PW department has been undertaken on the government road shown on the southern side of the DAG in the map. Therefore, the sum and substance of the aforesaid letter is that there is no land acquisition for constructing any PWD road is undertaken by the PWD department or any other government authorities as on date, full stop. In view of the aforesaid communications, a petition, an application for vacation, application for modification of the aforesaid order dated aforesaid order dated 13/8/2025 passed by a coordinate bench of this court was filed by the petitioner, filed by the respondent authorities. However, full stop. Mr. H. Sharma, the learned additional senior government advocate, submits that since there is no proposal of any acquisition of land of the petitioner in the instant case as on date, nothing survives in the instant petition, and the order passed on 13/8/2025 has also become has also to be termed as non-effective, to be termed as to be termed as non-effective due to the facts, due to the facts, due to the subsequent facts that have been brought on record before this court. Full stop. You have anything to say? I mean,
Lordship,
so I mean, it has become infructuous now. The learned counsel appearing for the petitioner has also submitted fairly. Fairly, you have submitted, right?
Yes, Lord.
Fairly, that there is
They-
no,
no, Lordship,
no,
they
no.
stopped the road because I filed this.
No, correct. I mean, now,
Lordship,
whatever it may be.
That sentence may be incorporated in case it is, if the road is
Correct.
constructed, Lordship, the due process will be followed.
As I have submitted that in fact, the in fact, the construction of the road has been stopped in view of the filing of the instant
Instant
petition
petition.
by the petitioner. C also submits that on a later stage, if any construction is to be made on the land of the petitioner, the same should be done by following the proper procedure under the Land Acquisition Act. Full stop. After hearing the counsel appearing for the respective parties, this court is of the considered opinion that nothing survives in the matter as on today, and if there is any proposal or any land acquisition for the purpose of construction of any road, then the petitioner shall be at liberty to approach this court if there is any violation in such acquisition of his land. Full stop.
Diplomats.
In view of the aforesaid, the instant writ petition is disposed of as infructuous. Full stop. The connected I also you pass an order saying that since the writ petition is disposed of, this connected this I is also disposed of.
Lordship.
Diplomats.
Where is the lordship? Kindly peruse order dated 10/12/2025, my lord.
Yes, Mr. Sharma, you need some time or you have
No,
got
Lordship,
instructions?
we have received the instruction, most probably this case also can be disposed of. As because under a wrong notion, Lordship, that order was passed. Lordship, may I please?
Yes.
মুখে দিলে এটা কপি, তাক দুটা কপি কৰি দিব দিছো। The last 2-3 lines, Lordship. No, Lordship, the first page, last.
Yes.
তাকেতো সেইকাৰণে কেছটো কৰিব।
So, I mean, they are saying that like that earlier mutation application was rejected. I mean, with due to some misunderstanding.
Lordship, that court case is pending, that is why. they
Correct, court
rejected.
case is
So Lordship
pending.
will apply, lordship.
You face.
Yes,
Yes,
Lordship,
Lordship.
that I have also been told that as because in a computer, Lordship, once rejected, it cannot be revived.
Revived.
So they have to.
You'll have to
apply.
freshly apply.
Lordship, I will apply freshly, lordship, may keep the writ petition pending, lordship, let it be after 3 months.
Why pending?
Lordship.
Why pending? I mean, they have given this instruction, I mean.
That will be a new cause of action, Lordship.
I mean, they have given an instruction before this
So
court.
Lordship, some
They-
specific. time
And
may be-
with specifically saying that it was done because the case was pending.
Lord.
And they are saying that they will consider your this thing on
within a time
merits.
period, Within a time period.
Hmm?
Lordship,
Okay.
they will file an application for mutation under the Seva Setu
Within
and
15 days, Lordship will.
Lordship,
they are
most,
Within 1 month, Lordship, then.
most probably there is some time bound is there, Lordship, mutation. ki baat aapko. Yes, Lordship, that notification is already there.
90 days.
Within 30 days, they have to,
They'll dispose it of.
if they fail, then they can prefer an appeal before the district commissioner. District commissioner will dispose of that appeal within 60 days. That notification is there, they have to follow.
Lordship will file. Proceed.
Lordship, the time stipulated is 60 days, Lordship, for the circle officer.
For the circle officer.
Yes, they have to apply for before the circle officer under that Seva Setu, that stipulated time limit for providing the service, total 60 days. If no objection from any person is filed during the proceeding. Thereafter, district commissioner or additional district commissioner, the appellate authority,
Hmm.
they have been given 30 days time. Then review authority is commissioner of the division, 30 days.
No, it involves some demarcation also or what?
No, Chief, I think
Demarcation is already over, my lord.
it's regarding mutation.
Lordship, on the basis of.
But like
application-
from the facts you have stated, nothing can be made out from here. Was there any order for this? I mean, what? I mean,
Lordship. In this case, Lordship, I have challenged the demarcation notice also, Lordship, but in terms of last, honorable court's order, demarcation has been taken place.
so where is that order?
Lordship.
Where is that order? The demarcation has been done and all.
Lordship, very first day's order, Lordship.
The pendency shall not be a violation.
Yes,
is
yes.
it?
That order is lordship dated.
Yes, I'm like,
1st August 2024.
okay, right, heard Mr.
R.K. Talukdar, lordship.
R.K. Talukdar.
Yes.
Talukdar, the learned counsel appearing for the petitioner, also heard Mr. H. Sharma, the learned additional senior government advocate for respondent number
2, 3, and 4.
2, 3, and 4. You are appearing, MS so-and-so for respondent number 1. Mohanta for 1, huh? The case of the petitioners herein is that the petitioner's predecessor in interest, namely one Tiken Chandra Bayan, was recorded as Pattadar in respect to a plot of land measuring 1 bigha 10 lichas covered by DAG number 2810 of KP Patta number 1316 of village Udal Bakra, Moza Beltola in the district of Kamrup in bracket M Assam. Full stop. It is seen that the petitioner numbers 1, 2, and 4 had filed a suit against one Makhoni Bala Day, which was registered and numbered as title suit number 421/2018. The said suit was decreed ex parte by the judgment and decree dated 5/5/2022, declaring that the plaintiffs and pro forma defendant a right to use and occupy the said suit land, confirming of possession over the suit land, and a permanent injunction was granted restraining the defendant therein from interfering with the peaceful possession of the plaintiffs and the pro forma defendant. Full stop. Next para. Thereafter, on 18/5/2024, a notice was issued to the Pattadars of DAG number 2810 and 2814 under KP Patta number 13. One to 2184, 2814 is also involved.
Yes, lordship.
Okay, you read 2814 under KP Patta number 1316 for their appearance before the circle officer, Dispur Revenue Circle, in view of the fact that the sale of the land covered by DAG numbers 2810 and 2814 under the KP Patta number 1316 of Udal Bakra, Moza Beltala in the district of Kamrup Metro, Assam, had been withheld on account of certain objections and accordingly directed the said Pattadars to appear before the circle officer, Dispute Revenue Circle, full stop. Accordingly, the petitioner submitted an objection. Subsequently, same parameter, on 8/7/2024, another notice was issued to the Pattadars of DAG number, to the Pattadars of the aforesaid 2 DAG numbers under KP Patta number 1316 in respect to a miscase number 480/2023 in connection with physical measurement of the land covered by the DUG numbers, aforesaid DUG numbers, aforesaid two DUG numbers under the KP Patta number 1316 of village Udal Bakra, Moza Beltala, whereby it was informed to the Patadars to be present on 3/8/2024 at 11 AM, for carrying out the physical measurement. The said notice dated 8/7/2024 has been put to challenge in the instant case before this court. Full stop. It is seen that by order dated 1/8/2024, the coordinate bench of this court has observed and directed that the respondents may go ahead with the physical measurement in terms of the notice dated 8/7/2024. Full stop. The learned counsel appearing for the petitioner submits that in terms of the aforesaid order dated 1/8/2024, the physical measurement and demarcation has already been completed on the aforesaid two DUG numbers, right?
Yes, Lordship.
Aforesaid two DUG numbers under KP Patta number number 1316 of village Udal Bakra, Moza Beltala, full stop, Gauhati, full stop. He submits that though demarcation has been done, the mutation of the petitioner's land has not been carried out by the respondent authorities. Full stop. Is respondent full stop. Then you write next para. The learned counsel, Mr. H. Sharma, the learned additional senior government advocate, has submitted a communication bearing number DIS D capital IS -4/2018 court /941 dated 02/04/2026. Issued to him by the circle officer, Dispute Revenue Circle. Full stop. The same is kept on record by marking X. It is revealed from the aforesaid communication that the mutation of the petitioners was rejected by the then circle officer due to a mistake, to the effect that since the instant case is pending, then mistake due to the effect that due to the pendency of the instant petition, the mutation cannot be done by the circle officer. Full stop. However, the mistake has been realized by the respondent authorities, and respondent authorities are willing, and the respondent authorities are willing to consider the mutation sought for by the petitioner. Full stop. The learned additional senior government advocate further submits that since there is a technical defect, there is a technical issue involved in the instant case. The petitioners have to file a fresh application for mutation in the instant case, as the digital portal for such applications of mutation do not accept an application which has already been rejected by the respondent authorities. So, also, therefore, he submits that on submission of a phrase mutation application of the by the petitioners, the respondent authorities will consider the same. Also, the learned counsel appearing for the petitioner does not have any objection to the aforesaid. Full stop. In view of the aforesaid, facts, this court is of the considered opinion that there is no point keeping the instant repetition pending, and therefore the same is disposed of with a direction to the petitioners to submit a phrase application for mutation of their land, at the earliest, and thereafter the respondent authorities shall consider the case of the petitioner in terms of the notification,
Now, office memorandum
in
dated
terms of the office memorandum dated
12th of April 2013
13.
regarding general guidelines
Hmm.
regarding the standard procedure to be followed for providing office mutation by revenue circle officers.
लिखा ना? In terms of the aforesaid, the instant application is disposed of.
Lordship. Much obliged.
I'll just come back in 5
Lordship.
minutes.
May I proceed? The petitioner vehicle, my lord, JCB was seized by the respondent authority, my lord.
Hmm?
JCB, petitioner's JCB was seized and taken custody of the respondent authority, my lord,
Hmm.
and imposed a fine of rupees 10,90,935 rupees, my lord,
For what?
for illegal cutting and extension of transportation of soil, my lord. But that soil is a Miadi Pattaland soil, my lord.
Hmm.
Admittedly, it's Miadi
Lordship.
Pattaland soil, and
They have to pay the royalty if that soil, mineral concession is taken for consumption in some other place. If they have used it for their own purpose, they don't have to pay the royalty. And as far,
Affidavit you have, why don't you file affidavit?
my lord.
we'll file affidavit, Lordship. Even there's a statutory appeal provision is there, Lordship. They have challenged the order to DFO.
Hmm.
Rule 68 says that any order passed, there's a provision for appeal, Your Lordship. Rule 68 of the Assam Mineral
Yes, my
Concession.
lord, there is a provisional appeal, but opportunity must be given, my lord. So national justice before appeal, my lord, they have not given any so cause notice, but imposing.
No, they'll give you a notice of, you can file an appeal.
Appeal, Rule
Yes,
68
my
says
lord.
that. He'll go for it.
This we can prefer a appeal before the, but originally no so cause notice was issued. my lord.
Correct
This-
now, no, I mean, for that purpose also, you could have gone
Yes,
for
my
the
lord,
appeal.
yes, my lord. And the vehicle is also lying in the open field, my lord, for last 1 year.
So let him go before the PCF, let him file the appeal, Your Lordship. Because he's challenging the order to DFO and the order to DFO is appealable before the PCF.
Which is the provisions for me?
Assam Mine Mill Concession Rules, 2013 rule. Assam Mine Mill Concession Rules.
So you file an appeal.
My lord, my
Hmm?
lord, my lord.
You should
Because
have filed by this time.
Before,
Your vehicle is lying there.
because, my lord, the pending case is pending, my lord, because if this independent, because whether they can.
No, we will,
consider my case or not,
we
petition,
will,
my lord.
we will dispose of this case, asking them to dispose, I mean, your appeal within a time.
Yes, my lord,
Hmm?
it may be done, my lord. Because 1 year, my lord, we weren't here in.
If it
Yes,
gives
sir.
me your book, I'll just pass an order.
And the excessive amount of cost also imposed, my lord.
So you
He
content all
can
those
raise all these
things.
grievance before the PCF.
You content all those
That
things.
is fine. If it is amount, low amount, my lord. that
Rule
is fine.
68, Your Lordship.
So you have not complied with 3.
Yes, my lord,
Yes.
that is, my lord. They have not complied, my lord.
I mean, it says any order.
No order, my lord.
Uh,
No order under this rule shall be passed by the competent authority against any person. He has been issued a show cause, my lord, and given a reasonable opposed to make the representation.
But is it for the appeals or like is it for what? But appeal to obviously he will only
Yes,
go.
my
There
lord.
is no,
Yes, my lord.
there is no question of giving him notice.
Yes, my lord.
Yes,
So it means that, I mean, any order passed by any competent authority that has to, I mean, he has to be given a show cause notice.
So cause notice. Here they challenge therefore saying that I have not been served any notice. Yeah, against that, he has a provision for appeal. In
The
the appeal,
provision-
he can contend that no show cause issues to us. And then penalty of rupees 10 lakhs and impose. Therefore, the PCF will give them a hearing.
Okay, we'll dispose it of.
My lord.
Heard Mr. S.
Yes, sir.
S. Sakia, the learned counsel appealing for the petitioner. Also heard Mr. R. R. Gogoi, the learned standing counsel Forest Department
Respondent 1, 2, 3, and 4, Your Lordship.
for respondent number 1 to 4.
I am,
Full
I am
stop.
for respondents of 5, my lord, private respondent. I am for 5.
Private
Honor of
respondent.
the Miyadi Patel and my.
Honor of the landman.
Okay. Mr. So and so, the learned, your name, please?
JP Chauhan.
Huh?
JP Chauhan.
JP Chauhan appears for respondent number 5. 5 full stop. The instant writ petition has been filed by the petitioner challenging the imposition of penalty ticket of an amount of rupees 10,000,
10 lakhs.
sorry, 10 lakhs 90,935. The writing words also. Upon the excavator in bracket JCB of the petitioner bearing petitioner comma bearing registration number AS01 stroke MC 3886 comma own 3886 as penalty by the divisional forest officer comma Kamrup East Division comma dated 30/4/2025 comma on the ground that the penalty imposed is highly exorbitant comma no show cause notice was issued to the petitioner prior to passing of the aforesaid impugned order, as well as for violation of the provisions of the Assam Minor Mineral Concession Rules 2013. Full stop. The learned counsel appearing for the forest department, learned standing counsel appearing for the forest department has pointed out that any order passed by a competent authority of the forest department and a person aggrieved by such order has a provision for appeal under the aforesaid rules, that is the Assam Minor Mineral Concession Rules 2013. Full stop. He submits that as per rule number 68, there is a specific provision wherein an appeal can be filed and a person has all the rights to contend his grievances before the appellate authority. Full stop. Now, you write, in this connection, in this connection, it may be relevant to refer to rules 68 of the aforesaid rules 2013. 13, which is extracted herein below. When you write 68, then you take it from here, 68. কিতাপখন আছে নি এখন আমার নাই না কিতাপখন নাই আচ্ছা হেৰি করো then you write you take it down then 68 then 68 then you write appeals 1 unless otherwise provided an appeal against an order passed by any subordinate officer shall lie with the director stroke principal chief conservator of forest and head of forest force, comma, Assam, as the case may be. Full stop. Number 2, an appeal against the order passed by the director stroke principal chief conservator of forest and head of forest force, Assam, shall lie before the government in the power, in bracket E, capital, E, Mines and Minerals Department in respect of minerals under schedule, in quotation X, and the Environment and Forest Department in respect of minerals under schedule in quotation Y. Full stop. Number 3, no order under these rules shall be passed by the competent authority against any person unless he has been issued a so cause and given a reasonable opportunity to make a representation. Full stop. The learned counsel appearing for the petitioner submits that in view of the aforesaid provisions under Rule 68, a competent authority, before passing an order, shall have to issue a so cause notice to a person who is affected by such order. Full stop. He submits that since there is a provision of appeal, he would like to prefer an appeal under the aforesaid Rule 68, and therefore he submits that a direction should be passed by this court to the appellate authority to dispose of his appeal in a specified time period.
And a speaking order may be passed.
Hmm?
Speaking order may be passed, a speaking order.
A specified time period by a speaking order, full stop. Taking into account the submissions made by the counsel appearing for the parties, this court is of the opinion that the instant writ petition can be disposed of by giving a liberty to the petitioner to approach the appropriate authority under Rules 68 of the aforesaid Rules 2013. Full stop. It is directed that on preference of an appeal under under Rule 68 of the aforesaid Rules 2013, the competent authority in the Forest Department shall pass a speaking order giving an opportunity of hearing to the petitioner within a period of 2 months. Within a period of 2 months. Full stop. In view of the aforesaid directions, the instant writ petition is disposed of.
Obliged, Lord.
কিতাপখন লাগিব পাবনে বিচাৰি পোৱা যাবতো পোৱা যাবতো অৰ্ডাৰটো পাছ কৰি যদি চাব লগা হ'ব পাৰে নিশ্চয় লেলি না বুক
May I please, Lordship? So matter pertains to non-payment of higher charge bill, Lordship. Non-payment of higher charge bill, Lordship.
Non-payment of higher charge bill.
Lordship, already they have filed it.
Where we have admitted the amount 19 lakhs 32,000.
What is their claim amount?
22 lakhs 91 rupees. Lordship.
And what is your amount?
19 lakhs 32,000, 118 rupees, my lord.
Paragraph 6, Lordship.
Paragraph 6 of my affidavit, your lordship will find.
What is to be done?
52.
So may dispose of within the time frame, Lordship.
You are happy with this amount?
Yes, yes, Lord.
This-
Three numbers of vehicle, Lordship.
How many number? Three numbers.
Three
of-
numbers of. vehicle.
Okay. Heard Mr. A. Deka, the learned counsel appearing for a petitioner. Also heard Ms. U. Das, the learned additional senior government advocate. For respondents, all respondents, for the respondent authorities,
All.
for the respondent authorities, full stop. The petitioner herein, who is the owner of 3 vehicles bearing registration numbers AS-13 F dash 8217, comma, AS dash 13 P dash 9396, and AS 01 dash FY 6728 is aggrieved by the non-payment of an amount of rupees 20 lakhs 91 rupees 22,000,091, which the respondents are liable to pay to the petitioner on account of requisition of his 3 vehicles. Full stop. It is the case of the petitioner that in spite of submission of several representations, the respondent authorities have not responded to the aforesaid representations. Being aggrieved, the petitioner has filed the instant writ petition, full stop. An affidavit in opposition has been filed by the respondent number 2 in the instant case, wherein
Starts from 50.
wherein at paragraph 6 Roman 1, section Roman 1, the respondent authorities have admitted to an amount of rupees 19,32,118. You write in words also. Only, full stop. The respondent authorities have have provided a detailed calculation for arriving at the aforesaid amount of rupees 19,32,118, full stop. The learned counsel appearing for the petitioner submits that he is agreeable to the amount so calculated by the respondent authorities and submits that the instant writ petition can be disposed of with a direction to pay the aforesaid amount within a specified time period, full stop. Next para. In view of the aforesaid admission of amount of rupees 19 lakhs, तो लिखा था वो लिख देना, 90 lakhs so and so, and 90 lakhs so and so, and aforesaid amount of so and so, which is agreeable to the petitioner. This court is of the opinion that instant case can be disposed of with a direction to pay the same amount, full stop. Accordingly, it is directed that the petitioner shall submit a representation along with the instant order before the respondent authority.
2 and 3 lodges.
Before the respondent authorities, that is respondent number 2 and 3, at the earliest, and on receipt of such application, along with the copy of this order, instant order, the respondent authorities, that is respondent number 2 and 3, shall clear the amount due as above stated within a period of 2 months thereafter.
4 months, man.
Other cases,
Huh?
4 months, man.
Not 4 months, 2 months, 2 months. You have taken his vehicle and you are not paying him. Amount has been admitted. 2 months is sufficient time. Elections will be over within a period of 2 months. Accordingly, the instant writ petition is disposed of.
The item, there is one more item 55, similar nature, Lordship. They are supposed to file
We have received the instruction, my lord, may I pray, my lord, to after
Yes.
my lord.
Instruction is what?
My lord, regarding my lord, his entitlement, my lord.
The admission is there, some admitted amount.
Admission is there, my lord.
So you can produce this, we can dispose it of that also. What, I mean, is it required to file an affidavit for that?
My lord,
You just go through it. I mean, if it is possible, we can be, I mean, we can, what is the admitted amount?
admitted amount is, my lord, henceforth amount, 42 lakhs, 89,078 rupees.
And what was the claim amount?
42,94,000.
So, I mean, on the basis of the instruction, it can be disposed of. What is the point of keeping it pending and filing an affidavit?
Lordship,
You place
I'll
it
take a
in-
photocopy of this, my lord. I have only one copies and I'll
Okay, you do one thing. I mean, I'll pass the order in, in terms of the earlier order only, because this is an admitted amount.
Ma-
Only thing is that you need some more time, then like say amount is little bit higher.
my lord,
So we'll give some more time. We'll give some more. 4 months, no, 3 months.
my lord.
Huh?
My lord, my lord,
3
come-
months will
So that's why, my lord, I'll provide a photocopy of this lordship, please to pass order according, on the basis of this instruction, and I'll provide your lordship a copy of photocopy, my lord, because I have only one copy, my lord. Lordship will get here, my lord.
Okay, Dave, but then we'll do one thing. I mean, you give the copy to the court master. After some time, you taking a photocopy.
My lord,
I'll keep this in this thing later on.
my lord,
Huh?
my lord.
We'll pass order later on then. You give me we give the court master a photocopy.
Copy.
Photocopy, then on the basis of the instruction, we'll dispose of this.
My lord.
In terms of the earlier order only, because this is an admitted amount.
Today lordship will dispose it.
So
So-
today we'll dispose it of. After some time, whenever you,
My lord, my lord.
whenever you submit this copy, then we'll pass an order. You may not be required to be present. I mean, we can pass, or if you're there, if you're there.
Lordship. Authority freezing of bank account, Lordship.
Yes, Mr.
Lordship, in fact, so far as respondent number 1 and 2 are concerned, they do not have any role to play here. A complaint was filed by the private respondents before the CVC. It's not like what is reflected in the order. In the order, it
Okay,
is
the initial complaint was filed before the CVC.
CVC, not before 1 and 2.
1 and 2 is the UP something.
Union of India and this, Lordship, there is an agency of the Union of India,
Hmm.
that is the cyber crimes cell. Now, the complaint was,
So it was not filed before the Indian Cyber Crime Coordination Center.
it
It was filed before the CVC, and
it
CVC has
transpired-
forwarded.
it transpires from the affidavit filed by the private respondent.
Hmm.
Now, I have taken it up with the CVC, and CVC Lordship says that it was forwarded to the Ministry of Railways for necessary action on 26/9/2025, and later on it was closed as no irregularity was observed. So there is no irregularity so far as the CVC is concerned, Lordship. And so far as respondent number 1 and 2 is concerned, 1 may not be here. 2's role is different, Lordship. What 2 has to do is, there is a cybercrime portal. And if a complaint is filed in that, it is put up in the portal, and thereafter the local law enforcing agencies, they take it up. Now, if the bank has freezed any account of the petitioner, the bank has to say on whose instruction they have freezed it. It is for the bank to say.
So after receipt of the CVC, they have verified,
They have verified and they have closed that complaint.
closed their complaint, saying that there is no
No
issue.
irregularity.
Huh?
No
No-
irregularity.
No irregularity in what?
In the complaint. They see only the complaint.
Huh. They say that the complaint is genuine.
Complaint has been filed against the petitioner,
Huh.
against the petitioner.
So complaint is genuine, they're saying.
The complaint is genuine.
Huh.
They have looked into it
Hmm.
and they have closed it as they did not find any irregularity. Any irregularity means like the involvement of the petitioner or so.
Okay.
So they have closed it.
Hmm. But they have closed it, but this how it has gone to this respondent number 2?
No, respondent number 2, it's a transaction of money. The respondent number 2 alleges some irregularity of the petitioner before the
No,
CVC.
no, no. It was filed before CVC.
Yes.
So CVC is not 1 and 2, right?
CVC is not one.
Not 1 and 2. CVC is an independent organization and they have found a complaint and they found that like complaint doesn't have any merits.
They forwarded it to the railways.
They forwarded it to the railways.
Railways.
Yes.
And later on, it was closed as no irregularity was observed.
So railways and CVC are concerned. They are saying there is no problem. I mean, there is no issue in this.
Yes.
There is no merit in the complaint. In the complaint. Now, this how this Indian cybercrime or coordination got this?
No, they have not got it.
They haven't got it. But they are saying that like it has been. You are convinced that.
Our account is already freeze, Lordship.
Correct. Then what happened?
The cybercrime, the respondent number 2 does not freeze.
Hmm.
It is not their duty.
They are not duty.
It is not their duty. They only maintain a portal.
No, but how they got, I mean, how this was, uploaded in their portal, portal.
That I don't know, Lordship. It is not that it was uploaded in the portal.
Do you say that like, is it a submission that it was uploaded in the portal?
Yes, Lordship. The bank informed that they.
Bank.
No, the bank has to say under whose instruction they have freezed it. Because in a similar case of.
No, but you are appealing for 2, right?
1 and 2.
Or 2. Then for 2, what will be your submission?
2, Lordship.
Because the bank is saying but because it was there in the portal, they have freezed it.
No. Bank cannot do on that.
No, bank cannot do on that, but like
the local law enforcing agency will, whoever is investigating the matter, they will ask the bank. That is the procedure. Now, who has asked the bank? That they have to disclose.
No, first of all, they will have to tell us that how this.
I will just.
From where they have got it.
Yes.
From where they have got it.
In a similar case, Lordship, I have instructions. I would just like to give a copy to your Lordship. Just for your Lordship's understanding how this respondent number 2 functions. It's in a different case, but it's the standard form, Lordship.
Let us understand that.
Yes. And there are some guidelines also issued that your Lordship will find in the second page. বেলেগ কেছ সেইটো কেনেকে কাম কৰে সেইটো কথা আহে কেৱল লোকেল লেভেলত যোন ষ্টেট এজেঞ্চি আছে যোনে ইনভেষ্টিগেট কৰি দিয়ে তেওঁলোকে বেংকক কয়
So lien is basically freezing, right?
Yes.
Holding or lien is a term used by them.
That will be only limited to the amount.
Yes, some complaint is there and they have been reported, then they can instruct the bank to do it. They can also do it seems. I mean.
No, that is the LEA, that is the law enforcement agencies.
Yes, law enforcement agencies. So, so basically, I mean, respondent number two never
No.
instructs a bank
No.
to freeze any account.
No.
It is the LEA who will do it.
Yes.
I mean, LEA will do it, I mean, because LEA is part of this, I mean, Minister of Human Resources and
LEA will be the law enforcement agency, but
Agency.
if your lordship will come to
No,
paragraph,
paragraph 2 says
no,
that
paragraph,
MHA will be intimated.
no, if your lordship will come to paragraph 8 of that, in the second page,
8.
Yes.
Yes. Submitted that as per article the public and police are subject.
the action is done by the state or
All reported complaints are dealt by respective state police office authorities based on the information provided by the complainant. And police. This has been online reported on the portal in those and through the link to module conference. See module developed by 14C MHA.
so if the bank lordship says on whose instructions, then it would be lordship. And it can
See, number 3 says,
lordship.
page 2,
Yes,
it is submitted that online financial transactional frauds
are reported in
reported on the portal. ठीक है?
Yes, yes,
And through the 130 helpline are linked to a module called Citizen Financial Cybercrime Reporting
yes, yes.
and Management Systems.
Hmm.
So this system is a module developed by 14C,
Yeah.
comma MHA
Yes,
to trace fraudulent money in the financial channel.
yes,
If the fraud money is available in the financial channel, the fraud amount is put on a lien that is on hold to prevent it from exiting the financial channel through a well-established coordination of
the
LEA
and
and bank and financial institutions. So there is a portal developed by the
Yes,
MHA.
yes.
So on the basis of, I mean, if there is a money, I mean, they have a suspect that the money will be exiting the channel, then they block it. Now, in his case, the case is different.
In his case, it's different lordship.
Differently.
His
So,
was
so
only
now,
five-
now banks has to, I mean, banks, you all have filed affidavit, right? Huh? So what is your instructions?
Instruction is we have received the instruction from respondent.
You are from SBI.
Yes, yes.
Hmm.
We have received the instruction from respondent number 4.
Who is this one now for?
Cyber cell of the UP police, Uttar Pradesh police. As per their instruction, Your Lordship, as my learned senior has said, it is the local enforcement agency. As per their direction, Lordship, we have to freeze the account.
What kind of information you have received from them?
Lordship, to freeze the account, there is some suspicious financial activities. As per their instruction, we have freeze the account.
That will be only limited to the amount. If there is more or so, that cannot be freeze lordship. As per the,
For the submission of language senior, Your Lordship, that's because after the investigation, nothing has been found. If there is a direction from the court, Your Lordship, the bank can unfreeze the account, Your Lordship.
Then Mr. Dev Chaudhary has to file an affidavit.
I can file an affidavit, but
You'll have to file a short affidavit saying that, I mean, nothing has been found. I mean, nothing.
that I cannot file lordship because it's the UP police.
No. I mean, UP police has to, UP police has instructed him to freeze it.
Oh.
But thing is that now, since you are saying that it was sent to CBC, CBC,
CVC is not a party here.
CBC is not a party. The problem is that CBC is not a party, but whether Union of India can represent CBC.
It can, but provided.
Then you can, for Union of India, you can file it.
But lordship will.
See, no, see, otherwise he's suffering. He's suffering because if you say that there was nothing was found and
Nothing was found in his complaint. In the complaint filed by the private respondent.
on the basis of the private respondent, I mean, this thing only, all his accounts have been defreezed.
But the freezing is not.
See, all the banks are saying only because of the this thing. UP police cybercrime sale, you have defreezed it, right? That is your statement. So,
If we
so-
present UP police, it will be difficult, but CVC, I can file a short affidavit, though not a party.
now CVC, now we do not know now UP police on what basis and
No, that is the thing.
and how they have received the complaint. We do not know anything.
If your lordship, I'll just take a chance. If your lordship will allow me some time, I don't know whether I will get any response. I will try to get in touch with the UP police.
That you to do, please. That then, I mean, otherwise it will be difficult to resolve the issue.
Yes.
You get, I mean, if possible, you get in touch with EP cybercrime and just find out what exactly happened. And if we get their person, then I think we can come to a conclusion. But without that,
But at any rate, lordship, as per the instructions in paragraph 9, if there is a disputed amount, the disputed amount can stay. It can be freeze. But if there is any further amount,
excess
that-
amount.
yes, that can always be transacted, lordship.
No, lordship, entire amount, entire account is full, lordship.
No, that cannot be done, lordship. That cannot be done.
Gain mark has to be for a certain amount.
Hmm?
Gain mark is always for a certain amount. Even if the account will be frozen in total.
So they have, but you all have frozen his account.
The fund is gonna be, the amount is 1,91,000, specific amount is. But interestingly, the balance is only 1,000.
So that account, it doesn't make any difference to you. But other accounts, you are saying that amounts are
Yes,
there.
lordship.
I mean, but we'll have to give them some time to file. I mean, what is to be done? The Mrs. Chaudhary is trying to help you out.
Complaint with council.
Who are there? Who are the from the complainants?
12, 13, 14.
They would be the best persons, lordship, the private respondents.
Nobody's
That
appearing
is
now.
12, 13 and 14. They have filed an affidavit also, lordship.
They also file affidavit, lordship.
Now they have filed an affidavit, but nobody is there today.
Because in their affidavit, they do not say that they have filed any complaint with the respondent number 2. What transpires is that they have filed a complaint with the CVC. Therefore, I got the instructions.
From
the-
there only, yes.
Yes. If they say that they have filed a complaint with the cyber cell, maybe I can.
One Mr. Mira was appearing for 12, 13 and 14.
No, Wait, what's up?
Okay, we'll give them some time.
Yes, lordship.
Hmm.
So excess amount may be allowed to.
No,
transaction.
that come in, I don't think, I mean, without the affidavit, we'll be able to
Was
do it.
only excess amount, lordship.
Excess amount, how will you, we will find out?
Lordship,
Now, which bank, how much
in
account?
case 11, lordship. In Bhavani Oil Service, lordship,
Hmm?
amount received 90,000. And now in their account, almost 6 lakhs is there, lordship.
Bhavani Oil, you have
Bhavani
received
Oil Service, lordship, I have received
90,000 received.
Yes, lordship, from respondent number 12, lordship. Baroda. And page number 12, lordship,
I have
Well, I mean, let them file an affidavit. We'll consider in the next date, not today. I mean, we'll see like what are the, why don't you file an affidavit? Huh? But you have been given time earlier also. You file a short affidavit, from whom you have got the instructions and all. Otherwise, it will be difficult to resolve the issue.
Whom and lordship the amount?
Hmm?
Whom and the amount?
I mean, stating about those things. Heard Mr. G.G. Gogoi, the learned counsel appearing for the petitioners. Also heard Mr. R.K. Dev Chaudhary, the learned DGCI, SI, for respondent number 1 and 2, Mr. B.J. Talukdar, you are a learned counsel for learned additional senior government advocate for respondent number 3, Mr. H. Borgohai, for the learned counsel for respondent numbers 5 and 8, Mr. M. Smith, the learned counsel for respondent number 6, Mr. A. Ganguly for respondent number 11. Who else? Huh? And Gayan for respondent number 10 and your name? Jair Islam for respondent number 7. And anybody else? Okay. None appeared for respondent number 12, 13 and 14, right, today? None appeared for respondent number 12. Then right, Mr. R.K. Dev Chaudhary, the learned DGSY, SI, Deputy Solicitor General of India, submits that the freezing of the concerned accounts of the petitioner was not done on any intimation of the respondent number 1 and 2. Full stop. However, he submits that it transpired that a complaint was filed before the Central Vigilance Commission, CVC. And the same was later on.
Lordship may see
No,
page.
I'll just write that,
What's the complaint number?
complaint number.
Yes.
Complaint, you write a complaint number.
Complaint number 126327
Hmm.
oblique 2025 dated 23/9/25
Before the CVC.
before the CVC,
And the same was
forwarded to the Ministry of Railways.
Ministry of Railways.
It was forwarded to the Ministry of Railways, and later on it was closed as no irregularity was observed.
And later on, it was closed as no irregularities was found.
And there was no direction from the Commission for freezing the accounts.
Then you write, he further submits that there was no direction from the Commission for freezing of any of the concerned accounts. Full stop. Since there is an allegation, you are saying that you people, no, they are saying, since there is a submission, and since there are submissions made by the concerned counsel appearing for the respondent banks, that the concerned accounts were in fact freezed on instructions received from UP.
Nodal Cyber Cell Officer.
Huh? From respondent number 4, that is Nodal Cyber Cell Officer, Uttar Pradesh. A notice has been issued by them or not? What was it then? Respondent number 4, huh? No showing sufficiency. However, it is seen from the office note dated 11/12/2025 that as far as the effect of service upon respondent number 4 is concerned, comma, an unserved notice was received back by the section, full stop. Therefore, none appeared for respondent number 4 in the instant case. The learned Deputy Solicitor General of India, however, submits that he would try and get, if possible, certain information by contacting the respondent number 4, full stop. He further submits that he would file a short affidavit by the next date, bringing on record whatever the instructions he has already received. Full stop. Full stop. Next para. None of the banks, respondent banks, have filed their affidavits in the instant matter as yet, and therefore they sought for a short accommodation of time for filing their affidavits, respective affidavits. Full stop. The respondent numbers 12, 13, and 14, the complainants, the complainants have already filed their affidavit in opposition, and the same is on record. Full stop. Next para. Taking into view the facts as discussed above, as well as the submissions made by the respective counsel, full stop. Let the matter be fixed immediately after the ensuing view vacation. Full stop. By that, you can file in a by that time. By that time, the respondents shall file their respective affidavits in the instant case. Let the matter be listed on later part of April, 30th of April. 30th of April. Okay, you'll have to wait till that. 30th of April. Whatever is there, you file it, but because this person is facing problem. I mean, I received another case also yesterday. Somebody put some amount in somebody's account. I mean, he doesn't know who is the person, and his bank account is freezed. And he can't operate. He can't operate now his usual business also.
But the whole account cannot be freeze, Lordship.
And I don't know. I mean, that has been freezed. And I don't know why bank is doing so. The bank councils will know.
Already an account is kept on hold, but in this case, also I think so the whole account is put on hold.
Now, other case also, what we received, the whole account has been freezed. They are saying that the account is freezed. So freeze means they cannot withdraw any amount. They cannot operate. It's not only about the whatever the amount. Now, court is also facing difficulties that without hearing the bank, you cannot just direct on the first date. You cannot direct and defreeze it. We do not know there what is there, what is not there. Somebody has a he had 2 lakhs something amount in his current account, and from some unknown source, some 5,50,000 was deposited. Now his whole account is freezed, so he is facing problem. So banks also will have to be vigilant, otherwise the people are facing problems. Now we understand about the bank's problem also, because so many these kind of frauds are happening. They need to also act very cautiously.
As
So he
per
play
the instructions, Lordship, that is the SOP for the all the institutions.
Correct. Please keep it on your go.
But
We are
that
keeping this
part-
on.
Yes, yes. But that pertains to some other case, Lordship.
I understand. I mean, just for the understanding of the mechanism actually.
Lordship, the instruction there, no?
Yes,
Paragraph 4, my lord, while replying, my lord, Roman 2, your lordship will find.
Roman,
Roman 2, my lord, that 4, next page, lordship will find. Of paragraph 4, Roman.
yes, whereas the actual claim amount should be 42,89,000.
And my lord, yes, and breakup also, the, like earlier order, my lord, there is the breakup also in the annex.
So this is the admitted amount.
Lordship.
So this can be also disposed of with
No, no,
this.
same line.
I'll just put
Sub-
this on record.
My,
and then,
as a man.
what was which was the earlier matter?
26.
26.
26 we have taken. No. So 26 is similar order will go. Huh? This amount is there. Out here there is no affidavit, but instruction has been received. So we'll mark it X. I'll dictate. I'll pass the order.
Lordship,
Huh?
lordship.
And then
Some more time may be granted, man.
Huh?
3 months.
That will do. That
Here it was 2 months.
Lordship.
3 months.
3 months will be.
Lordship.
None appeared for the petitioners when the matter was called for. Let the matter be listed in the month of May.
I need some time. I'm telling affidavit. Not for filing. I have to file my affidavit, Lordship, because some amount has been admitted, but they are not accepted that amount, Lordship.
What was the claim amount?
29 lakhs 77, 29 lakhs
29 lakhs.
77,491, Lordship.
But they are saying 16 lakhs 77,000.
Lordship.
RTI reply also page number,
So I have to file my.
page number 17.
Hmm.
Kindly see, it's outstanding liabilities is 29 lakhs 77,491, Lordship.
RTI replied, they said that was the admitted amount. That was the
Yes,
amount due.
Yes, Lordship, page number 17.
Okay, I mean, let them file an affidavit then. Heard MSO and so the learned counsel appearing for the petitioner. Also heard Mr. N. Upadhyay, the learned standing counsel for irrigation department, full stop. Mr. Upadhyay prays for some accommodation of time to file the affidavit in opposition in the instant matter. Full
In the
stop.
month of May, Lordship.
Let the matter be listed in the first week of May.
Lordship.
Item 37, my lord.
Yes.
In this case, actually, as regard submission notice, that case is ready, my lord, but till now the affidavit has not been filed by the respondent, my lord. Which are that renegation matter, my lord, for claiming compensation, my lord.
So affidavit will be required.
That will be required, my lord.
You have not received the instruction as yet.
No, ma'am. On behalf of District Commissioner as well as ADC.
Item number 37 and 30,
36 and 37.
36 and 37. Okay, then we'll post it after the vacation.
No, my lord.
Okay. Mr. N.C. Das, the learned senior counsel, assisted by Mr. M. Das, is present for the petitioner.
Environment government.
M.S.M. Burman, the learned government advocate, appearing on behalf of respondent number
Lordship. 6 and 7.
6 and 7 submits that she is yet to receive the instruction in the matter. Therefore, she prays for some accommodation of time to complete her instructions, full stop. Instructions, comma, which is not opposed by the learned senior counsel appearing for the petitioner. Let the matter be listed after the ensuing vacation.
Obliged, your lordship.
36 and 37.
It's a second bail application, my lord. At this stage, my lord, diary may be called from.
Mr. You were there in the matter when the matter was heard earlier?
My lord.
You were there, it was rejected earlier.
Yes,
You were
sir.
there.
My lord,
Do you remember?
that time, my lord,
Hmm?
Mr. Goswami was
Mr.
hearing.
Goswami was appeared, okay.
But my lord, that is not clearly reflected, my lord. But
From the
otherwise,
case-
my lord reflected this,
Hmm?
that, my lord, when rejecting, my lord,
Hmm.
that the court has heard the submission made by the learned counsels appearing for the.
But I think like the case that it was considered, but I mean,
Because otherwise,
it
my
was
lord,
not
heard
recorded.
both the sides and my lord, thereafter,
Recorded,
my lord
but-
reflected that part. My lord, the matter is rejected, so my lord, city may be called for, my lord.
Okay, heard Mr. N.J. Datta, the learned counsel appearing for the petitioners, also heard Mr. K. Bosho, right?
My lord.
Okay, Bosho, the learned APP for the state, full stop. Call for the CD and, no, you write one line, the matter. Then you write that this is an application of the so-and-so. Then you write NFI was lost on 22/12/2025 by the informant, alleging that she was in a romantic and physical relationship with the accused applicant for 1 year or so. However, on 21/12/2025 at 2:30 PM on receipt of a phone from the accused applicant, she went with him inside the vehicle, the accused applicant tried to have sexual intercourse with her, full stop. When she denied for the same, he tried to forcefully commit the offense, full stop. An anticipatory bail application, that is AB stroke 4750 stroke 2026 was filed earlier, and after consideration of the same, while ordered at 16/3/2026, this court has rejected the aforesaid anticipatory bail application. Then you write call for the CD. Then you write this is second AB application, anticipatory bail application filed by the accused applicant. Call for the CD. Let the matter be listed after the ensuing vacation.
22nd or 23rd, any date?
Let the matter be fixed on 23rd.
20.
I'm obliged. 23rd. Kita mati mana? Ini kita mati. Pusat. Kita. Kuntu. Nah, hearing kita. Itu kena fix house. So, this. Okay, kuna sir, mati dia.
WC 195426 from October 10.
Perfect.
What is the urgency in the matter? Why at 2? Why?
Lordship, the other benches heard similarly, other petitions, part heard, all matters have been part heard, similar petitions
Where?
in court number 10. You know.
Not
Huh?
part, not part hard.
Part
Yeah,
heard.
no,
Other interim orders were part, all are similar matters.
orders were passed and those cases.
Now,
have
why
come-
it has been sent here?
The similar cases have been listed before this court. Court
I-
said things will, matters are similar. So we have passed orders, let the matters be taken along and sent to this.
The similar matters have been heard by this court.
No, no.
Oh,
Similar matters are listed today.
huh.
In this course.
That were heard earlier.
One second, one second, one second.
Item 44 and 45.
56, 57.
44,
44, 45 listed today before this honorable court.
okay,
Along with supplement.
According to my friend, Malad, those are similar matters.
okay.
Therefore, the court number 10 has expressed that since the matters are there, already some orders were passed in the other cases, let this go to the same court and the honorable court will consider.
Okay, they have item number 40,
44, 45.
44, 45.
56 and 57.
Hmm?
Supplementary list 56 and 57
44,
and 51.
45, then
51,
51,
supplementary 56 and 57.
56 and 57.
Yes, Your Honor.
Okay, all these matters are listed here.
Yes.
That's why these matters have been sent to this court.
Gotcha.
Okay. Okay, some what order was passed earlier? Jurisdiction 44 to the compound. Yes, I mean, we'll have to issue notice on these matters also.
Malad,
These two
the-
matters.
The item 44, 45, I appeared in those cases.
Hmm.
Though, Malad, the item 44 is connected to Goalpara district.
Hmm.
In that Malad case, I have got the instruction that after eviction, they are now occupying in a private patta land. Malad, they are facing difficulty with the drinking water, health and Malad, medical facility, sanitations. Their lordship has directed us to take instruction, we have taken and accordingly passed an order. In these other matters, Malad, some is from Kamruk, one is from Nagaon, different areas. Without instructions, Malad, it is difficult on our part to place it before your lordship. Because after eviction, they are now occupying, somebody may have occupied another government land, somebody may have, as I have seen in the Goalpara case, they are occupying private patta land. Somebody else's have patta land, they have allowed the encroachers to stay there. And Malad, my instruction is that if they are having some ration card, definitely they can go to that particular shop and avail the ration. And the nearby hospital is there, they can very well avail the medical facilities. So those things are there. I have no instruction as regard the Kamrup district. One matter item is Malad, item number 17.
So you have instruction only in 44.
44, yes, Malad. Item number 45.
45.
45.
45, you have instruction.
45, yes, Malad. 45 and 44.
45 and 44, you have received instructions.
I
They are
have
from Goalpara districts.
They are from Goalpara district.
Goalpara. And in both these matters, they have settled in private patta land.
Private patta land.
Private patta land, and
Yes.
somebody has allowed them to stay there.
Somebody has allowed them to stay there.
Stay
And-
there.
and
So you don't have any issue in that.
we
Huh.
don't.
But the only thing is that, like, as far as, I mean, whatever rehabilitation, all these things are concerned, since they are not staying in a rehabilitation center, you are saying that, I mean, they can avail the facilities, whatever, I mean, they are eligible to.
They have Malad, various grievances.
Hmm?
They have various grievances. They have
Hmm.
said that drinking water is not there.
Hmm.
Therefore, Lordship has directed us to provide potable water.
Hmm.
That has been complied with.
They complain.
Secondly, Malad, they have said that health issue is there
Hmm.
because no medical facility has been
Hmm.
given.
Hmm.
My instruction is that nearby hospital is there.
Hmm.
They can very well in the vicinity only, there is a hospital, they can go there and avail that. As regard the education of the children, Malad, there are two schools. They can go and that is school is available. As regard the ration cards, Malad, they have said that the ration is not available to them. Whoever is possessing the ration card, they can very well go to that particular shop and they can very well take the ration. So that is how the instruction has come and the grievance of the petitioner has been taken care of. I have no instruction as regard the
Other cases.
Nagaon and other cases.
So 56, 57, 51, 56, 57, you don't have any instructions.
No.
And this matter has come, these two matters have come newly. So we'll
Newly.
have to issue notice on that.
Logic.
Notice on that.
Give us some time, I'll obtain the instruction in the case.
Yes.
Your Lordship, in item number 45, WPC 2026, some interim orders was passed earlier. So,
45, 44, he's saying that like that as per in terms of
So-
the earlier
my
order.
humble submission, Your Lordship, kindly such interim orders may be passed because they all are living in the same situation. They are all similarly situated persons, Your Lordship. They're staying in some makeshift camps without the bare basic amenities of life, Your Lordship, after the evictions. Because they are basically river eroded landless people. They don't have any other land to go. They are, as such, they are staying in such places, in such an inhuman condition, Your Lordship. Already this court has passed some.
So is it for river erosion or they have been evicted from unauthorized occupation?
Unauthorized occupation.
They are-
Then where is the question of river erosion?
Basically, they are all river eroded people and being river eroded, they are landless. So they are occupying some government lands and subsequently they are evicted. As of now, their position is same, Your Lordship. As of now, their position is same. They're staying under the open sky without the sanitation, drinking water, medical facility, all these things, Your Lordship. In some.
So,
In a-
so as for 44 and 45, I mean, they are saying that they have complied with.
Yes, but
So,
item number this,
no, 44 and 45, then what remains in the matter?
Lordship, we have seeken a prayer regarding the settlement, Your Lordship, because until and unless they have provided some land, because they are landless people, Your Lordship. Had they been their own land, they could not stay in such an inhuman condition, Your Lordship.
But in the other matters, I would pray, Lordship may give us some time. But after the, let it be after the vacation.
Then what about the rehabilitation that their settlement they are saying?
But they are encroachers. They
They're not encroachers.
originally, they are encroaching government land.
We are landless people.
No.
We're Indian landless people. How can you term somebody as encroachers? My landed friends.
But anybody who stays in a government land without an authority, they are encroaches.
That part.
Whether you are landless or whether you are with the land, you'll have to take permission before settling in a government land. Correct. So I mean, whatever is your status, that's a different thing. But if you stay in a land owned by government without any permission or I mean, whatever the required this thing, then you're encroacher. But now,
Categorize the.
But as far as like absolutely, you are absolutely right. As far as like other certain basic amenities, I mean, whatever, then they're saying that they have complied with.
Well,
Same may be compliant with this.
that is the immediate cause which is expressed before the Lordship, and Lordship is taking up the matter at 2. Because those are the immediate cause. Rehabilitation is a policy matter, my lord.
Correct.
That Lordship may give us time because we have to respond to that. Because all the.
No. Why I'm asking is that like, I mean, now, as far as 44 and 45, they are saying that like they are giving you whatever the requirements are.
Yes, he
I
agrees.
mean, you are fine with that, right?
Lordship, as per the last order in WC 888W2, around only 8 hand pumps are installed. No sanitation facility has been provided till date. As per my information, as on today morning, Your Lordship. So,
Because that I had some. We have prepared the budget. Last order reflects that.
You are paying for?
Each, I follow my print out matters. I mean, very hurried manner. But see, it's legible, 4 number of pumps have been installed, 20 numbers of toilets are there. And we are giving him daily 3,000 liter tank water. And the fund is under process now.
What is under process?
Fund money, we have, the demand was a huge amount of 33 lakhs rupees required to
provide the man-to-man, family-to-family ratio. That is another process. And in the meantime, the MCC has come. Funds cannot be because that is awarded by tender, my lord. The industry is. There is not one single problem. They're scattered in
Various areas.
Those are Kartal and private Kartal and.
So you have the similar prayer, right?
Yes, Your
The
Lordship.
other petitions
Other
also?
petition.
Okay, we'll do one thing. See, Mr. Nath, as far as the earlier matters are concerned, you'll have to complete your instructions probably. So 44, 45, 51, 56, 57, you'll have to complete your instructions and file an affidavit. File affidavits in the matter.
Madam.
And as far as these two matters are concerned, we'll issue notice on these matters. And in the meantime, yeah, I mean, by the next date, if you can file affidavit, you can file affidavit.
Lordship, I did.
And in the meantime, I mean, whatever, I mean, the earlier order is there, interim that, I mean, water and all that.
In fact, a small instruction is required for that also, because Lordship has taken up the matter, and on the basis of our instruction, that Lordship order was passed. But if I'm a prey, that Lordship may kindly take it up on 22nd or 21st, because before 9, it is difficult on my part. Today is 6th. Officers are not in a position to give me instruction yet at this stage, kindly considering the situation. Let it be on 21st, 20 Lordship is opening. 21st or 22nd, I pray. On that day, kindly consider that. Because I don't know where they are staying. In Nagaon and Kamrup.
Lordship, I'm sorry for the interruption. That in this series, Lordship, item number 51 is also stated, but 51 is a different case level. It's regarding demarcation. 51 is not there. Okay.
51. Okay, 51 is different. 51 is different.
Different.
Borderline 51 is different, right?
56, 57. Your Lordship.
Okay, you write in, I mean, at first I will pass order on 44, 45, 56 and 57. So 44 and 45, you have, I mean, complied with whatever.
Some instruction we have, and we have also complied to that, to some extent.
Correct,
My
correct.
friend has also placed the instruction.
Okay, you write, Mr. Jet Khalid, the learned petitioners, you write in 44, 44 and 45. Jet Khalid, learned counsel for the petitioners, also heard. Mr. Gogoi is also appearing. Mr. B. Gogoi, the learned additional advocate general, Assam, appearing for the health department, Assam. Mr. D.K. Nath.
For respondent number 3, 4, 5 and 9.
The learned senior government advocate for respondent number
3, 4, 5 and 9.
3, 4, 5 and 9. 3, 4, 5 and 9. And anybody else you are appearing for?
Revenue Department.
MS and Bordole for learned standing counsel for revenue department. Mr. D. Gogoi for PHC department. Full stop. The learned Mr. Nath, the learned senior government advocate, submits that in terms of the order dated 25/3/2026. Just like they write like this, Mr. Nath, the learned senior government advocate, on instructions, has submitted that in terms of the order dated 25/3/2026, the facilities for drinking water has already been made. However, as far as implementation of a comprehensive rehabilitation and resettlement plan is concerned,
We have no instruction to that effect. That is their prayer. As regard their prayer for rehabilitation.
Okay, correct. Cut this. That is their instruction, yes, yes. The direction was regarding water, then
Sanitation,
VSOPs, then healthcare
sanitation.
and sanitation.
Lodge.
So, so as far as water is concerned, you have you are saying that you are complying with,
Potable water.
and as far the other things are concerned, you don't have the full complete instruction as yet.
To the,
You file an affidavit.
Facilities we are providing.
Okay.
And if there is any issue, the facility will help us. You can approach the nearby PHC or CHC, whatever is there.
Ne-
Where they will just be out of free of cost. Then we are stating that we will just be a file today.
there is a
Okay.
hospital nearby. They can approach.
We have filed that. Including maternity and all.
And you write, Mr. Nath, submits that as far as water is concerned, that has been provided. Whereas Mr. B. Gokui, the Learned Additional Government Additional Advocate General, for the health department, appearing for the health department, submits that the required health facilities have already been given to the petitioners, and in case of in the event of any emergency, there are primary health centers in the locality which the petitioners can avail. Full stop. To that extent, an affidavit has already been filed by the health department. Full stop. Mr. Gogoi, you will file an affidavit? You file short affidavits, then whatever. Mr. Nath also has to complete and file an affidavit.
An affidavit we have filed, but detail I'll file.
Mr. Nath and Mr. Gogoi, appearing for the respective parties, have submitted that they will file their respective affidavits in a short while, and therefore praise for some time. Let the matter be listed on when? After the ensuing V vacation.
Not
After the ensuing V vacation, after the ensuing V vacation. So 44, 45 same order will go. 44 and 45 write the same orders, and 56 and 57.
Same method.
Similar order, so similar order will go. But as far as but you don't have instructions on those matters.
They're all
Those are from Gauhati.
same campaign.
I have no instruction. I have instruction only in 44, 45.
Then you write, I mean, in 56 and 57, you write, Mr. The learned senior government advocate submits that he requires some more time to complete his instructions, and prays for requires some time to complete his instructions. Full stop. Let the matter be listed along with the other matters, two matters after the ensuing V vacation. Full stop. That will suffice in this. Okay, let him complete his instructions.
Yes.
And item number this. One second, don't take. To follow this one.
No, not to come. Not to come. Another one.
The same prayers, no? Same prayers,
prayers.
same this thing, grievances.
Same grievance.
These two matters have come for the first time today. I have to for a short time.
So notice will be issued on.
Mal.
So kindly some interim direction may be given your lordship for drinking water, sanitation, health and all facilities.
So we don't know their position. That is what
We-
difficult.
I'll come to next.
Some instruction is required. If necessary, lordship may take up on 22nd or 21st for consideration of that interim.
Similar orders were already passed, Your Lordship.
The parties will be saying heard so and so, right? Now, which district is this Islampur, this thing?
Kamrup Metro, Your Lordship.
This is the Kamrup Metro, this.
Kamrup Metro.
But I have seen some areas which
Evictions were
Both-
conducted by the Kamrup Metro.
those might have under Kamrup rural.
Now, item number, this thing, item number, one of this, I mean,
But WPC 1954.
WPC 1954. So that is Kamrup Metro.
Kamrup Metro, but area indicated is Polasbari, Ajara, maybe in the Kamrup rural also.
Sampat maybe in Kamrup Rural.
Polasbari revenue circle falls, as per my knowledge, it is Kamrup rural.
You write heard so and so, so and so. The instant writ petition has been filed by the petitioners alleging that after their eviction, the eviction drive conducted by the respondent authorities in Kamrup Metro District on 14/3/2026 and 15/3/2026 respectively. They have been evicted from their settlements and
No, they were in tribal block,
Huh?
tribal.
Huh?
They were in tribal belt, para 8, page 22.
no, they have been evicted from their settlements. That's what I'm writing.
They, from their encroachment.
That's what. They have been evicted by eviction drive dated so and so. They have been evicted. Evicted their unauthorized settlements in different places of Kamrup Metro districts, and thereafter they have been staying in open areas near Islampur, Pasanipara, etc. without having any facilities of drinking water, adequate food, sanitation, or medical facilities. The petitioners have filed these petitions specifically praying for those facilities, from the respondent authorities, full stop. Let not, party, anybody is, I mean, who is not appearing? Formal notice has to go, or everybody is present.
We represent.
Represent, no? Since the respondents are duly represented by their respective counsel, no formal notice is required to be sent. However, extra requisite number of extra copies to be served on the counsel appearing for the respondent authorities within 2 days from today. Full stop. Let notice be issued, returnable in 4 weeks. Same order will go in for this other item also.
1980, WPC 1980. Lordship.
Oh, the only thing is that place is different.
Yes.
Place is Nogam.
Place is Nagaon,
No.
for instance. That I'll correct it. I'll make this whatever, I mean, like required, the necessary thing I'll do it. So other case, the place will have to change. That this is from Kamrup Metro, that is definitely from Nagaon, and like they have been evicted from forest areas, right? That will have to mention. The item number 1 and 2. These matters also will be tagged with the other matters, 44, 45 and all these matters. All these matters will be tagged together and listed on the same date.
Highlight.
Yes, how much time you have? I mean, usually I don't ask, but there are
Yes, yes.
some matters are,
Yes,
I mean,
yes. I
remaining.
noticed that, my lord. I
So,
noticed
so
that.
how much time both of you will take?
I think I'll take around half an hour. I'll try to finish in half an hour. My lord, then
1 hour.
will-
So shall we start or will, I mean, I mean, I don't want to keep you, I mean, senior counsel waiting
That
also.
is, my lord. Lordship may not say that, my lord.
Hmm.
I'm always present, my.
We'll take it up now.
I'll leave it to your lordship. Lordship, whatever.
What I am feeling,
Hmm.
to be very honest, because below my matter, I have seen there are so many matters, my lord. For me, everybody will start before vacation. That's what I'm just thinking, my lord. If your lordship say that I'll start, I can start. But what I'm thinking, my lord.
We'll take it up at 3:30. By 4:30, you can finish it up, both of you.
If something is left, your lordship can also take it up tomorrow, day after tomorrow, because he has to reply.
Tomorrow, no. So there are other matters are there.
Okay, we'll take it up at 3:30 if it is not inconvenient to
Sir, yes,
both
sir.
of
We'll
you.
look thereafter what can be.
Yes.
Then 3:30, we can take it up. 1 hour, I think we can finish it up because already we've heard the matter.
Yes.
Substantially heard the matter.
Right.
So we'll take it up at 3:30
I'll
and
look
1 hour, I'll try see like, I mean, because a lot of
My
councils.
lord,
Yes, sir.
not less than
Huh?
1 hour.
No, let us try.
We'll try it, let's see.
Yes, fine.
I mean, let us see how the, I mean,
Yes,
I
progress.
mean,
Yes.
proceeding progresses.
Obvious.
May I please, your lordship? Lordship, the petitioners were,
No,
some
no
cases-
affidavit has come. We'll have to wait. You'll have to wait.
Lordship, I have an order dated 22nd January 2026 addressed to the petitioners.
Hmm?
Addressed to the petitioners wherein the forest has submitted that after verification, the lands of the petitioners are actually revenue patta land.
No, no, you have the instruction, but I don't have any, I mean, I don't have anything from the other side. Who is appearing?
But if I'm praying for some more time, Lordship.
They are saying it is a revenue land.
Yes, Lordship, that is why, Lordship, we have been directed to obtain instructions that because of this election, Lordship, that is why.
Okay. Heard MS?
A.H. Atia.
And
AA?
A.H. Atia.
A.H. Atia. A.H. Atia, the learned counsel for the petitioner, also heard Mr. H. Sharma, the learned additional senior government advocate for all the respondents.
no, Lordship.
No, not all the respondents.
1, 6, and 7.
1, 6, and 7.
Okay.
Also 1, 6, and 7. Also, Mr. Sharma submits that he is yet to receive the full, receive the complete.
No, Lordship, we have already prepared the affidavit and sent it for vetting.
Okay, this is already gone.
So,
He
Lordship,
has,
that is.
he has already received the instruction and in terms of the instruction, he has already prepared an affidavit which has gone for vetting. He prays for he prays for a short accommodation of time. Prayer is allowed. Let the matter be listed when? After the ensuing vacation. After the ensuing vacation. Or in the month of May, first week. Because,
That will be better, Lordship.
in the month of May. In the first week of May, let the matter be listed in the first week of May. You are appearing for somebody?
For the forest department.
Mr. So-and-so for Forest Department. They are saying that like it is not under forest.
Yes, sir,
land.
the forest.
Whether you have any instructions?
No, Lordship, we are trying to conduct a joint verification report, but due to some issue.
You please do that.
Some.
Much obliged, your lordship.
My lord, this letter, my lord, is not file affidavit, Lordship.
Hmm?
Is not file affidavit, Lordship. Matter relates to Lordship, petitioner submitted an online application, Lordship, for settlement of his land, Lordship. And thereafter, Lordship, his application was rejected, Lordship. On the grounded land, the land comes under the vulnerable landslide.
No, no, if, I mean, there was some issue about factual stuff, whether this is maintainable. Mr. Sharma,
Lordship.
see, in the earlier order 232026, a coordinate bench is opined that the noticing the rejection is on factual aspect.
Lordship.
Which
The maintainability point is
maintainability is there. Is it maintainable?
as because this
If
is
it is not maintainable, we will not keep it pending.
under the domain of the civil court, Lordship.
I pray for some time, Lordship. I clarify, Lordship.
No, no, you have filed this application, Mr. Bhuya.
One single debt, Lordship. I'm praying
Huh?
for one single debt, Lordship.
See, if there are
That not-
factual aspects, I mean, factual aspect, I mean, earlier this was considered by a coordinate bench.
My lord, my lord.
And there is a specific opinion has been,
My lord, in this matter, Lordship, my lord, my senior advocate, senior counsel,
Who?
Mr. N. Sharma was appearing, Lordship.
Huh?
Mr. N. Sharma was appearing.
who is
Lordship.
Sharma?
N. Sharma, my lord. And no, my lord, he is appearing, Lordship, last, so Lord.
Okay, okay, parties are duly represented, and in the right, like that, this, Mr. D. Bhuya, the learned counsel for the petitioner, and Mr. H. Sharma, the learned, additional senior government advocate, appeared for the state respondents. I mean, G. Hazarika is appearing? G. Hazarika appears for respondent number 1 also. On the prayer of the learned counsel appearing for the petitioner, let the matter be listed after the ensuing jurisdiction.
Next, there on the point of maintainability. Lord.
The point of maintainability, the submission, the consideration of the point, consideration on the maintainability of the petition is kept open.
Lordship.
None appeared for the petitioner when the matter was called for. Let the matter be listed after the, in the month of May.
The petitioners is for seeking compensation against acquisition of land. No affidavit has been filed. as of now.
Sometime.
Heard Mr. R. Bora, the learned counsel for the petitioner. Also heard Mr. N.
Das.
N. Das, the learned counsel appearing for
4 and 5 months.
4 and 5, and you? 1, 2, and 3. Mr. Das submits that he requires some time to file an affidavit in the instant case. Prayer is allowed. Let the matter be listed in the month of May.
May I pray for a date?
May. I mean, so many dates are given. Come on, please, come on. 36. 36 is 36 is mentioned, no? 36, 37 mentioned.
36,
36, 37.
I am appearing for question number 4 and 5.
No, Mr. N. Das was there, senior counsel,
Yes.
NC Das was there, and respondent was also there. No,
4, 5.
we have already given time.
Oh, yes, that.
We have already given.
That's why.
Oh, okay. I mean, Burman was there and Mr. Das was there.
In this case, no instruction is required, Lordship.
Okay, we'll look into the next
Yes,
date.
already
Next date.
noted,
we'll look.
yes.
My lord, there is a direction in earlier petition, my lord. The
Huh?
direction was on the page 66. That question is that they have given the settlement in the mezzanine floor, the fish traders.
No, what do you want now?
Now, my lord, that's to comply with this order because 2 years passed, my lord.
And then we have filed an contempt, but this honorable court has suggested us to repetition because after 2 years. So,
I mean, they are raising the issue of non-maintainability.
my lord,
Okay, heard Mr. They are, I mean, we'll have to give them some time to file affidavit.
my lord,
Heard Mr. M.J. Borwar, learned counsel for the petitioners. Who is appearing? State?
my lord, this is GMC.
GMC.
Mr. Bora, S. Bora, my lord.
None appears for the. None appears for the respondent authorities when the matter was called for. Let the matter be listed after the BU vacation.
On that,
That lot of matters have been already built. Huh? Because the registry will have problem in giving the dates. So many matters have been already fixed. So they will give it a date.
May it pleases your lordship. Petitioners are the acid attack victims, lordship, and they are entitled for an compensation of additional compensation of rupees 1 lakh, lordship, and the coordinate benches also has passed that order in other acid attack matters, lordship. So I'd like to place before lordship. One is WPC 149/25. One is
Who is appearing? Who is appearing?
That is CGS. But report has to be sent by Deputy Commissioner of the concerned district, lordship.
So Deputy Commissioner has to
The
represent who is
District
appearing?
Commissioner now, District Commissioner.
Yeah, District Commissioner.
Kamrup Metro, lordship.
Who is appearing, District Commissioner?
You have communicated to legislated 16(3) self-finance.
You have communicated?
Yes, yes. But other prayers are there, but this I'm praying for interim, lordship.
No, interim will consider when, that report has to go, report, without the report, how can it be?
Report has to go to the, because after the incident within, as per the notification, lordship of 2016, within 5 days, it has to go. Now,
They should what, they should themselves, they should send it.
yes, because once the FIR is lodged, coordination has to be there, lordship, and this report has to be sent to the
Sent.
government of India, because this relief is an additional relief under the PM's fund, lordship. Additional relief of rupees 1 lakh.
It's a central government fund.
Yeah, it's a central government fund. And state under the victim
So,
compensation.
so this report will go from district commissioner to the central government
Yes.
organization, whoever
Yes,
it is,
Department.
Home Department.
Home Department.
And on receipt of the report, the Home Department will release the
So will
fund.
transfer, because in the report, they have to collect their bank.
So when
account
can you,
details
when
and
can you, when
details.
can you get, get it done? I mean, see, acid attack case.
Lordship, but after vacation, my lord, I will try my best.
No, we'll put it after the vacation. Heard MSD Ghost, the learned counsel, appearing for the petitioners. Also heard Mr. M. Bourbon, the learned counsel, appearing for
Order number 2,
respondent number 2 and 6.
2 and 6.
2 and 6. Madam, you are appearing?
V4.
MS so and so, 3 and 4. CGC, no, nobody is there. CGC, you are there? You can appear. Mr. A. Datta for Mr. A. Datta, the learned CGC for respondent number 1. It's only one or somebody else is also there?
Only one, lordship.
Only one.
Rest are all state.
Respondent number 1. They learn MS Borman submits that though they have communicated, they have sent a communication for instructions, the same is yet to be received, and therefore prays for some time to complete her instructions. Full stop. In view of the aforesaid, let the matter be listed after the ensuing BU vacation to complete the instructions by the respondent departments, by the respondent authorities. So you also see whatever is there, Mr. Datta, because
Already I
ultimately.
have served, lordship. Notice was issued and I have served the copies, lordship. Already I have served the copies. On the
So
last
you'll have to,
occasion.
because you'll have to consider this, so you also seek instructions, what is there or not there, okay? So we are putting it after a bill vacation.
I humbly pay for a fixed date, Lordship, since.
Dates are, are becoming difficult because so many dates we have already given. The registry will find a problem. But if you want a date in the month of May, we can give you.
First week of May.
First week of May we can give you that. Let the
Yes,
matter be
Lordship.
fixed on. Mm, Let it be on 12th of May. 12th of May.
Otherwise, second is a working Saturday, Lordship. We can.
No,
have
no,
it
12th of May. 12th of May we'll give.
12th of May.
12th of May.
Give to me.
In this matter, my lord, I have received instruction.
What instructions?
Regarding the occurrence of incident, my lord, the circle officer report negated, my lord.
Hmm?
There is no flood-like situation. And first page, my lord, that Office of Circle Officer so-and-so has submitted detailed inquiry report wherein Gaon Pradhan and Latmandal reported that no storm occurred on 19/3/2024 and death of late so-and-so occurred while cutting a tree and was not due to storm and any natural calamity as claimed.
Yes, your lordship. As per the police report, your lordship. As per the police report, your lordship.
We will put you in, inside your family members, whoever filed this case, this kind of cases.
Lordship, and
Somebody dies in the village and you come with a petition for ex gratia, for whatever reason.
maybe your lordship, there is.
What may be?
Lordship, the
No,
government.
what may be? Don't give this kind of smile before this court. What may be? You can file case for, somebody dies for certain reasons. You can come and like ask for this government ex gratia money. It's a public fund. What is to be done in this case? Tell me.
Lordship,
There is a specific report that there was no storm or storm occurred. The
Lordship,
death is
the
not because
statement-
of that.
The statement has been taken by the revenue.
Hmm?
The statement has been taken by the revenue department, your lordship. The circle officer,
Hmm.
who's Gaubura? Gaubura belongs to the resident of the.
So those things will be considered by this court. That Gauhati is from the different village and this was different village.
He is
So
questioning the authority of government officials who have.
so
responsible for your-
so now this this report is not correct. Is it so?
He should
Please
not
some
come in
time for
26
the
months.
instruction.
No time. We are dismissing it right now. Who has filed this petition?
Wife of the deceased.
Hmm?
Wife of the deceased.
And you are the counsel from the you are the counsel from the beginning.
No, but from writ petition.
Yes, from the writ petition only I am saying.
Yes.
So without verifying the facts, you have filed a writ petition.
As per the police report, your lordship.
Where is the police report?
Police report at page 23, your lordship.
Page 23.
Okay. Type of your.
Annexer?
Annexer 4, your lordship. As per 23, your lordship. And 4 is vernacular. 24 at best, 24 is vernacular, your lordship. Final report, your lordship.
How much is the ex gratia for this kind of debts usually?
Lordship, it's amounting to, I think, 4 lakhs, my
Hmm?
lord. 4 lakhs, my lord.
4 lakhs.
Time to time, it is varied, my lord. And so far as police report is concerned, they are only mentioned the cause of death, my lord, which has been forwarded. But the reason stated for death in the writ petition doesn't tally, my lord. কেনেকে join process কৰিছে সেইটো সম্বন্ধে non stated আছে। That is we are discussing. Reason not correct. No, no.
No, this police officer should be also called.
Maybe, my lord.
Why he is, I mean, giving this kind of reports?
My lord. But you could find the amount of expense at page 43, my lord, first column regarding date.
I'll pass the order and I'm dismissing this. If you want to challenge the order of the circle officer, you challenge it. Okay. And I mean, we have recognized your face. So this kind of cases you file without verifying the things, then it will be difficult. Difficult for you. Yeah. Please verify the facts before filing this kind of cases. Henceforth. So you are a young person, you have a career. Don't file cases just like that, only because your client is saying they filed this case. Don't file these cases. You write, heard Mr.
Yes, I can.
The नाम कितना लिखी रखो, Bormon लिखी रखो.
3, 4, and 5.
And I'm keeping this
Lordship,
with me.
maybe
So I'm dismissing the petition. I'll pass
my
the order.
instruction may be kept as part of record, my lord.
Yes, yes.
Public.
Yes, Lordship, as per last order, Lordship, Senior Counsel, Mr. BJ Taluda is supposed to, Lordship, appraise this court whether the order dated 23/23 was by the coordinate benches.
Which one is the coordinate bench order?
Lordship will find at page 25, Lordship.
Page 25.
Lordship. Of my petition. Lordship will find the order portion, Lordship will find
25.
Order starts from 50, page 50, Lordship. And the operative portion, Lordship will find at last page, Lordship, 56, paragraph 13, Lordship. Last page, Lordship.
Okay, you are saying that like, your case will be covered under this.
Under same, this, order, Lordship. Same village, same, or project, Lordship, lands
Hmm.
were.
Your land was acquired,
Yes, Lordship.
hmm?
Yes, Lord.
And you have not been paid or you have been paid?
No one is paid, Lordship.
Hmm?
As per their affidavit, Lordship, till date, they have not paid, Lordship.
Okay, who is appearing? Who is appearing?
When the petitioners of this Lordship petition which I have referred, Lordship, they are also not getting as per affidavit, Lordship, although amount has been sanctioned. Village is same, Lordship.
This matter, my lord, the senior counsel, Mr. BJ Talukdar is appearing, my lord. His legs on another court may be taken up tomorrow, my lord, if otherwise not inconvenient.
The only thing is, only instruction is that whether this will cover or not. I mean, the
Lordship.
earlier order.
Lord.
Earlier order by a coordinate bench will cover or not. That much instruction.
Actually, I have not seen earlier, my lord, so I need little time, my lord, to go through that order. Order copy is number two DDM, I don't know. Let, make it tomorrow, my lord. If not,
Tomorrow it will be difficult. I mean, I'll pass it over for time being. You just get the instruction.
Lord.
If Mr. Talukdar is there,
Lord.
see like if he hears the
Lord.
instruction, then we can probably pass some order.
Lordship, lord.
If he doesn't have, then we'll see.
Lord.
We'll find out. Hmm?
Non-payment of contractual bill, petitioner's father expired. But that written,
This matter already instructions,
yes,
Lordship.
amount has been paid.
Paid already.
That confirmation I have.
Okay, heard Mr. MS.
M. Borua, Lordship,
M. Borua
for petitioner.
Okay, M. Borua for the petitioner. Also heard Mr. B. Gogoi, the learned additional advocate general for respondent number 1. The learned counsel appearing for the petitioner submits that the petitioner has already received the amount claimed, and therefore the instant petition has become infructuous, full stop. The matter, in view of the aforesaid, this matter is dismissed as infructuous.
Instruction was called for.
What is the case?
Lordship, actually the validity of fixation of the ceiling,
Validity of?
fixation of ceiling period was over. Because the petitioner, they provided wrong details, bank details. So we need further time, Lordship, the new financial year.
They have provided you wrong details,
Yes, Lordship, their bank details.
bank details.
FISC code of
Okay, well then we'll put it some other time already. Heard Mr.
J.M. Sulaiman.
Sulaiman, the learned counsel for the petitioner, also heard MS so-and-so for
For the respondent 1 and 2.
respondent 1 and 2. MS so-and-so submits that she requires some more time to complete her instructions. Let the matter be listed after the let the matter be listed in the month of May.
Same, Lordship.
Hmm?
Same.
Same is the 49, same order. Huh? Mm.
Also from the office note, service is not completed. I have taken a step. Wait for service.
Okay, heard Mr. So-and-so.
Lordship, I am appearing for respondent number 11.
One second. Heard Mr.
Here, Mehdi.
A.R. Medi, learned counsel for the petitioner, also heard
P Das
P. Das for
for respondent number 11.
respondent number 11. Respondent number 11.
Name has not been reflected, my lord, though we have.
One
printed
second,
out
one second, one second. As seen the office note dated 31/3/2026, which reveals that neither AD cards nor any unserved notice have been received back from respondent number, received back in respect of notice and notice upon respondent number 9, 10, and 11. Full stop. Await service report, let the matter be listed after the ensuing vacation.
No, Malad, instruction is awaited from the government side also, so we'll need some more time.
No, I mean, let to be, our service is not complete. You pray when the matter comes. You complete it by the time. You are Mr. N. Das for
Mr.
2, 3, and 5.
2, 3, and 5. And you?
6 and 7.
6 and 7. M. Das for 6 and 7.
Last week of April.
Huh?
Last week of April.
Now, in the month of May. Listed in the month of May. In the month of May.
Month of May, my lord.
First week of May, first week
Yes.
of May, first week of May.
Yes.
Second week of May, second week of, first of May will be little bit rush, second week of May.
My lord. No, my IA was clear. One IA was I have filed.
I for what?
IA for stay for eviction, my lord. That is my,
No, which matter is this?
the same matter, my lord. In the same matter, I have filed a IA, my lord.
No, let them come up with the
Let
instructions.
the, my lord, service be completed.
Let them come up with their service. I'll just come back in 5 minutes. 5 minutes. Just.
Eleven to appear with, no? Extra copy nine, reading by nine or 10 to appear for nine. আমি তো 11 হলো আমার কিছু সুবিধা নাই তাহলে আমি কইছি যে রায়ত হয় মানে রায়ত হয় 11 নি যে রায়ত বাকি খালি এটা প্রবলেম হৈ আছে যে রায়তে 70% পাব লাগে বুলি ক্লেম কৰাটোহে আমি আপত্তি 94351 4785 আদাৰ পাৰ্টত আমাৰ কথা নাই 47853
Yes, Mr. Talukdar, have you received any instruction on this?
We don't know instruction, no, so they have annexed one similar order. It was as per the arbitral award manner, it has to be done, reassessment. Now this.
No, they are
process-
saying that like the assessment that has been done has to be same.
Same.
It will be covered. So whether it will be covered or not, have you taken any instruction?
I have not taken instruction, but it appears to be covered.
Hmm?
That will be, my
So
lord,
they are only asking whether the valuation, right?
reassessment
Reassessment.
in terms of the arbitral.
Arbitration award.
But arbitral award, you are not a party.
That
Arbitration lordship is cover all lordship,
It covers all.
all lords. On the basis of the arbitral award, then DC, Deputy Commissioner has passed reassessment order. That was set aside by this court. Asked to lordship to categorize the land lordship as per the arbitration award. And that reassessment has been probably done, lordship, but in our case, lordship, that is not only because lordship, we are not party in that earlier, this High Court case, lordship.
The
That is the only-
direction, your lordship will find that paragraph 13, my lord.
Yeah,
Party
I've seen that.
Man. By classifying the lands in two or more different categories, homestead and arable land, etc., in terms of arbitrators.
So similar order can be passed, I think. Only thing is that you'll have to classify those land, their
Classify
land
and-
also.
and
that has
verify
to be
also.
done.
Huh?
And verify also whether.
After verification, you'll have to classify it
Mine.
in terms of the same order.
Lordship.
The similar order can be passed probably.
Mine.
And we can dispose it of similar,
No.
passing the similar
No.
order. So we'll pass the order then.
Lordship.
You write
Authorized.
the names, sir. Write the names. Take their names and I'll pass the order. So we'll dispose of this in terms of the order passed by this court, because they are only asking for classification.
Lordship.
They are saying that like, their land is also covered under the arbitral.
That will be verified and.
That will be verification has to be done. After verification, a classification has to be done.
Then.
And if you are aggrieved by the classification, then you have to challenge it
Then again.
Then we'll dispose it of.
Mine. Deep progress.
Obliged, lordship.
In this case, we have been directed to obtain instructions. I am praying for some more time.
But in the meantime, my lord, office note 31, 31st/3/2026 shows that service upon notice item has been delivered. So service is completed. Let it be for admission hearing.
Right, I heard Mr. M.R. Khandekar, the learned counsel appearing for the petitioners. Also heard Mr. H. Sharma, the learned additional senior government advocate for respondent numbers 3, 4, 5,
And
and 6. MS PR Mohanto, the learned standing counsel, revenue department for respondent numbers 1 and 2. As per the office note dated 31/3/2026, the service is complete in the instant case. Service of notice is complete in the instant case. Let the matter be listed for admission in the usual course.
My lord, this date, my
No,
lord,
no, no. That will be difficult now. That will be
In the first week of May.
That will be difficult. Lot of matters have been given. I mean, only services completed. Wait for some time.
May please, your lordship. My lord, in this matter also service is complete as per office note dated 33/2026.
So we'll put it for admission.
This will be for admission. Interim order can be continued until further orders, my lord.
Heard Mr. D. Chakraborty, the learned counsel for the petitioner. Also heard Mr. MSPR Mohanto for learned standing counsel for Revenue Department. Revenue Department, that is respondent number 1. Then your
I'm for the respondent number 5 and 6.
MS so-and-so for respondent number 5 and 6.
Lordship, yes, Lordship, we have filed the Bakalat number today, so Lordship, we will, in the meantime, we will file the affidavit.
5 and 6, who? 5 and 6?
Private respondent.
Respondent number 5 and 6, okay. Yes, for respondent number 5 and 6. Mr. H. Sharma for respondent number, additional senior government advocate for respondent number
3 and 4.
3 and 4. 3 and 4.
After Board of Revenue,
Huh?
2, I think.
2 and 4.
Yes, lordship, 2, 3, 4.
2, 3 and 4. 2, 3 and 4. Service is complete in the instant case. Let the matter be listed for admission in the due course.
Interim can be continued.
Interim orders of past orders shall continue till the next date of listing.
Or until further orders, that will be convenient, since my lord is not fixing any date, so until
No,
further.
no,
orders-
ठीक है, I mean, till the next date of listing,
My-
same
my-
thing.
my-
Lordship, I think whether a court is to be a quasi judicial Assam Board of Revenue. Assam Board of Revenue, in my opinion, should not be make a party, lordship.
I'm challenging the order passed by the chairman. So generally, the practices that we implement the.
When we pass, challenge an award of the labor code, we never make labor code a party, lordship. So in that case, lordship, I do not want to let the notice go, lordship, to respondent number 2.
The notice has already been issued and it has been served also. for
Lordship,
the
lordship. Then
Notice has
lordship.
already been served.
Okay, Leb, I mean, if you have any issues, then you can raise it. I mean,
Lord-
as far as this thing is
Lord-
concerned.
Lord.
If you say that like this is not a required party,
Yes,
Then
lordship,
you
not
can-
required, that's because lordship, it's
then that can be considered.
lordship, lordship.
Obliged.
Yes.
Much.
May it please your lordship, in this matter, service is not complete, so we may be allowed to take dusty steps.
Press service.
Your lordship, dusty, because the matter relates to closure of the bank account on account of 20 rupees that was deposited, which appears to be a cyber crime. So just for that 20 rupees, my account is blocked, and my loan, the NOC against the loan, that I have not been granted the NOC certificate by the bank. So that aspect is also there. So I may be allowed to take dusty steps.
Trustee and Bandhan Bank.
Just yes, your lordship, respondent number 2.
Once anybody has appeared. The Bandhan Bank is a known bank. I mean, why dusty is required?
Your lordship, as per the office note, AD card is not received yet, and there's urgency because the account is closed and I'm not being able to.
Okay. Heard Mr.
C. Gogoi, your lordship.
C. Gogoi, the learned counsel, appearing for the petitioner. None appeared for the respondents. Full stop. Office note dated 31/3/2026 reveals that neither AD card nor any unserved notice regarding service of notice on respondent number 2 has been received by the section. Full stop. The learned counsel appearing for the petitioner submits that there is some agency in the matter as his account has been freezed.
Account has been freezed, yes.
Account has been freezed, full stop. Therefore, he prays that he should be allowed to serve notice on respondent number 2 by way of dusty mode, full stop. Prayer is allowed. The counsel for the petitioner shall serve the notice by way of a dusty mode and thereafter file an affidavit in proof of service of such dusty notice before this dusty mode, full stop. Let the matter be listed after, let the matter be listed in the second week of May.
Your lordship, first week of May, because.
Okay, first week of May.
Much of.
Well,
My lord, just one thing I just,
Yes.
my lord, I have got latest judgment of this honorable court. It was passed on the 16th of October 25, my lord, regarding maintainability in respect of association, my lord. Lordship, kindly have a look, just 2-3 paragraphs, my lord.
Hmm? Paragraph?
Yes, paragraph 8, 10, 8, 10, 11 and 16. Paragraph 8, page number 5, my lord. Learned State Council has however raised a preliminary objection on the maintainability of a writ petition by contending that petition number 1 association is not a registered association and therefore there is a legal bar for institution of the present case. He also submitted that since admittedly a suit has been filed which is pending, present writ petition has in fact become infructuous and is liable to be dismissed. He has however candidly admitted that state has not filed an affidavit. Now paragraph 10, my lord. Mr. Gauhati, Learned Counsel for the Respondent 8 has endorsed the submission made by the Learned Counsel for the State Council and has objected to the maintain of the writ petition. My lord, then your lordship may come to paragraph 11.
Paragraph?
11, next page.
Mhm.
The relevant part I'm just saying only, that's all. Mr. Kakoti, Learned Counsel for the petitioner has rejoined his clarified that objection regarding registration of the petitioner one association would not be valid such and such. My lord, may come to 5th, 6th, 8th line. 1, 2, 3.
Read the whole thing.
Okay. Association would not be valid objection in view of the fact that association was already registered and at the time of institution of the writ petition, the application for renewal of the registration was pending and his statement was candidly disclosed in the writ petition. By drawing the attention of this court to the affidavit in reply dated such, he has submitted that in the meanwhile, the registration has been renewed and it clearly appears from the said renewal that petitioner 1 was enjoying the status of a registered association. He has otherwise submitted that that aspect of the registration would not be an absolute bar for adjudication of an issue which involves a violation of the fundamental rights of the petitioner. In this regard, he has relied upon the judgment of the Honorable Supreme Court in the case of Akhil Bharatiya, such and such, my lord, Shoshit Karmachari, 1981, wherein it has been laid down that even an unrecognized association, but this is the case of Justice Krishna Iyer, my lord. The other day I have read that the judgment, my lord. Now, if you will also come to paragraph 16, my lord. On the issue of objection raised by the Learned Counsel of the respondents on the respect of the registration, non-registration of the petitioner number 1 association, this court is of the opinion that powers exercised by the writ court being plenary in nature, whereby the ultimate objective is to ensure that justice is done. Such objection can be treated to be technical objection only. This court, however, hastened to add that if the cause of action is directly connected with such aspect of the registration, non-registration, the same can be an issue for adjudication. However, in cases where the association espouses the cause of its member, such technical objection may not be a valid objection for adjudication of the actual issue before this court. The court has also noted that apart from the petitioner number 1 association, there are 4 other petitioners who are member of the petitioner number 1 association and are also affected to be impugned in such and such, my lord. In this case, Akhil Bharatiya, that my lord, petitioner judgment, the following observations were made, my lord. That particular paragraph 62 that day I read, my lord, this paragraph, my lord. It is broad-based and people-oriented, envisions access to justice through class action, public interest litigation, and representative proceedings. Indeed, little Indians in large number 6 remedies in court, such and such. I read that up.
Yes, they have relied on that,
Yes,
I mean,
yes.
in this case, that case was relied on.
Yes, my lord. Yes. My lord, there's another one of Calcutta High Court, my lord. Paragraph 10 and 14, my lord.
Paragraph
10 and 14. Page number 3.
this.
Yes.
10
Mr.
and
Prasad,
14.
learned advocate appearing for the Union of
One
India.
second.
My lord. Paragraph 10 and 14.
Yes.
Mr. Prasad, learned advocate appearing for the Union of India, dispute the contention raised by Mr. Sach. He raised an objection to the maintainability of the writ petition at the instance of the association. He further submits that the instant writ petition involves disputed question of fact which cannot be decided in a writ petition. Then the 14. The petition number 1 is an association registered under the West Bengal Societies Registration Act. The object of the said society is to look after the welfare of the officers of BSCL. The instant writ petition has been filed by the registered association to expose the cause of the members. To the mind of the court, this writ petition at the instance of the registered association represented by its general counsel is maintainable. This is another case, my lord. Then paragraph 15, just let me read. The issue involved in this writ petition is with regard to the interpretation of the terms and conditions of the voluntary retirement scheme and as to whether members of the association are entitled to certain benefits as per the said scheme. In view of the considered view of this court, writ petition does not involve disputed question of fact. 16. The petitioner association filed a writ petition claiming that some of their members who are applied.
Which para?
16.
16.
Small paragraph.
Now 16 of the Supreme Court case.
No. This one, that Calcutta High Court.
On that already they have decided.
Yes. Lordship has seen this one, no, my lord? Calcutta High Court?
On 10-14.
No, that is 10. Calcutta High Court is 10-14, yes. 10-14. Yes. Lordship has seen that one. Okay, ma'am.
Which one now? Which one is you are referring to?
No, it's all right. 10 and 14 I'm referring.
10 and 14, yeah.
Yes.
Then the Supreme Court case, this DS Nakara?
Yes, Nakara, my lord, paragraph 63 only. One paragraph. Page 37. Pages are at the bottom numbers. Last part, one page.
Yes.
Locker's Stendai of third petitioner question. Petition number 3 is a society registered under the Society Registration Act. It is a non-political, profit and voluntary organization. Its members consist of public-spirited citizens who have to take up the cause of ventilating legitimate public problems. This society received a large number of representations from old pensioners individually unable to undertake a journey through labyrinth of legal judicial process, costly and protected, and therefore approached petition number 3, which espoused their cause. Object for which the third petition society was formed were not questioned. Majority decision in the S.P. Gupta versus Union of India 81. My lord, this is that first judicial officer's case, my lord. And second is the judicial officers about the judge's appointment and the transfer. Rules that any member of the public having sufficient interest can maintain an action for such judicial redress for a public injury arising from a breach of public duty or from violation of some provisions of the Constitution or law and seeks enforcement of such public duty and observance of such constitutional or legal provision. Third petitioner seeks to enforce that rights that may be available to large number of old infirmary employees. Therefore, the local standard is unquestionable, but it is a point of academic such and such, my lord. Here, kindly see, this person, response number 3, is a third person here. Even Honorable Supreme Court has upheld that. They don't have anything to say about the pension. It's third persons, that was allowed. So my view is, my lord, from all these judgments, my lord, this is a, but consider all these facts. It's the lordship may consider, my lords. And my humble submission is, my lord, his decision and petition is maintainable, my lord. That's not my lord. So this is about the benefit. Now about the merits part, my lord.
Mr. Gogoi has anything to say on maintainability? You support him?
Yes. Private assessment.
Yes.
If I may just interrupt once. Before my respected senior starts on merit, I have other objection also with regard to this case. So may I place those? If he must.
The objections, I mean, you see, you have filed a petition for vacation.
Yes, your lordship.
So
Therefore,
what
I would-
other than maintainability, what else you
My
have?
lord, one thing, maintainability about that association, that plea has not taken in the affidavit, neither in the IA nor in the affidavit.
That is a legal point they are issuing.
I have taken it. I have taken
But
it.
anyways, no, I mean, what other things you want to?
Your lordship, the first thing I would like to redress your
No, no,
lordship on
he-
disputed question of facts.
Then that will be on the merits.
If your lordship if he wants to argue, let him argue and finish, then I'll reply. I'll take hardly
No,
20,
no.
25 minutes.
No, I mean, one you're saying disputed question of facts.
Yes, your lordship.
And what else?
Then non-implement of affected parties, your lordship. Then no challenge to the provisional gradation list. And finally, I would like to submit that there is a concealment of facts.
That you are submitting the merits only.
Yes, your lordship. Then I'll make my submission. Let him submit.
Because we are hearing the matter for finally.
Right, your
So
lordship.
you can raise the.
Okay, I'm obliged, your lordship.
My lord. Lordship, please come to page number 18, my lord, of the writ petition.
Page number
18.
of the writ petition, right?
My lord.
Yes.
My lord. Here lordship will find, let me read the order, my lord. In partial modifications of this directorate order number such and such, following LBS, lady health visitors, LBS means, my lord, lady health visitors are hereby temporarily promoted to the post of PHN, public health nurses, under the additional chief medical health officer at ANM training school, who have completed 1 year diploma such and such. Lordship, kindly see, all these persons, 12 persons here. Next page number 10, similar order. Page number 10, similar orders.
No, page number 18 you're showing, no?
18, yes.
So
There the
18
LGS have been promoted to the post of PHN. We are those PHN. We are the members of the PHN association. Public health nurses.
So you are the member of the association.
Yes, madam. The similar orders in page number 10, 2021.
22.
Yes. And also page 22. These are the persons, my lord. There are 27. 13 is retired, 14 remains, my lord.
So I mean, you are representing them.
Yes.
Yes. So
Now-
initially 12 and later on another 14.
Yes. 14 and then 1. Those are the persons PHN, my lord.
Hmm?
They are the public health nurses. They've been promoted.
Hmm.
I want to submit now. So far, these public health nurses will be concerned. Under the rules, my lord, rule 2.1. Now, if you come to the rules, my lord, I just try to become precise and the pinpointed. That's right.
Rules from
Rules. Other day, let's see the file.
Has it been given earlier? No.
Yes, that day I have shown to you.
Huh?
So I have the matter.
Itu file or something.
That day argued in lordship has seen that. So anyway, I got it. File is also very voluminous.
I have a copy. If your lordship wants, I can submit the copy.
No, if you have given it, then it should be here. I mean, I don't know why. Must be there.
Yeah, I got the copies, extra copies.
There are 2 IS files. What?
The first one was for implement, your lordship.
Huh.
And this is, the other one is, that 297 is for
Lordship,
stay vacating.
Lordship may take this rule, my lord.
The rule, one second, one second. It is there probably. We have.
Yes. So kindly see my lord, rule 2I. No, they are 2I.
Yes.
Service means the Assam nursing services. Now kindly see 3B.
Yes.
That is class 3. Who are the persons here? Fourth line, kindly see, my lord. Fourth line. It started from matron principal, fourth line.
PHN.
Tutor, public health nurses, PHN. Yes, my lord. So, this PHN falls within the cadre and within service. Service means Assam Nursing Service.
So you fall under class 3.
That's what I'm saying.
Class
Now this
3?
has been amended and this has been made, my lord, class 3C now. But doesn't make any difference, my lord. This fall in the cadre. The amended one I have seen, I have given to your lordships, my lord. In the amended one, there's a copy, my lord, I have given. This is amended copy one. I have given that copy. Lordship may take my copy.
One second, it may be here. It's 1998.
1998.
Yes, your lordship.
Page number 2.
Page number 2.
Two in my written part is 17 written there. And the second page, yes.
Second page,
yes. Kindly see to amendment of rule 3. Kindly see C. It is in principal rule, in rule 3, after sub rule 1, for existing clause B, the following shall be substituted as clause B. A new clause shall be inserted as clause C. In the clause
So some of the I mean categories.
Yes.
They have made
In
class
C.
2.
Yes. In C.
The earlier class 2 was not
No,
there.
class 3. It's class 3. C. Kindly see C.
No. What I'm saying is the earlier class 2 was not there or what?
No, it was there. They have what they have done. Class 3, it was A and B. Now they've made C. Little more.
No, the rule you have given there in 3 under 3.1. There are 2 classes. One is class 1 and one is class 3.
Class 2 is not. That's 2, my lord. That's 2, I think.
2 was not there or what? That's what I'm asking.
Probably, my lord. Actually,
It appears that it was not there, your lordship.
No, actually, I have also copied this rule from the writ petition filed by another the earlier, my lord. From there, rule is not available, my lord.
No, class 2 is not there. Now they have made one more. I mean, they have categorized it to. They have corrected it probably. They make it class 2, one category. Class 3 and one
Basically,
category.
that is a correction, lordship.
This is correction.
Basically, that is the correction in the form of an amendment. Your lordship is right.
So class 3, now they have categorized. I mean, you are already there in class 3.
Yes,
earlier also.
yes.
Now also you are in class 3.
Yeah, but they made it under clause C. That's the difference.
Class 3.
Okay.
Now, kindly come to rule 22. Rule 22. We have given the page mark as 11. I think your lordship has got original rule.
Gradation list.
Yes. A gradation list containing names of all members of service in order of seniority, stating the cadre in such other particulars as to the date of birth, date of appointment, caste will be prepared and published every year, my lord.
So there is no ambiguity. There has to be one gradation list.
Yes, one list. And everybody's name, those who are members of the nursing service, their name should be there. So since under rule 2, 1 or 3, I also belong to a cadre, my lord, nursing service. My name ought to have been there under public health nursing. That is the main issue in this case.
Yes,
Now, regarding this interpretation of Rule 22, there's a judgment by this honorable court.
yes.
That lordship will find, it starts from, my lord, page number 43. An operative portion starts from, the judgment starts from page 49. Start from page 43, it's also by association,
Page 43.
43, Annexure 7, writ petition.
Yes, page 43. It starts then.
It starts from page 49.
Hmm.
Can I read, my lord, this one?
Yes, yes.
Because these, I'll rely on this also.
Page 49. Yes,
Page
yes.
49, yes.
Hmm.
Let me read the full, my lord.
I mean, it's the same book of the case over. No different.
No, this is different.
Okay.
This is by association. This is graduate nurse association, this is,
Hmm.
this case. This extraordinary jurisdiction conferred upon this court by Article 26 of the Constitution of India is sought to be invoked such and such. Challenge a process of promotion of the rank of assistant matron, assistant nursing superintendent, such and such, my lord. The principal ground of challenge this efforts the recruitment process is that rules holding the field, Assam Nursing Service Rule 21, have been totally overlooked, by which prejudice and legal injury has been caused to the petitioners. The petition number 1 is an association of the graduate nurses, namely all Assam Graduate Nurses Association. 2 is the General Secretary. It is the case of the petitioners that to be eligible to be recruited as staff nurse, which is anti-cadre in the of the aforesaid rule, 2 streams are available: BSc nursing and GNM. Since academic qualifications of the graduate nurses higher grade pay provided to them. However, once they merge into the cadre of staff nurse, candidates from both the streams become eligible for promotion to the next higher post of ward sister, tutor, public health nurses, tutor, depending on the criteria provided under 1991 rules. It may be mentioned.
But how can, but I mean, you can't become, I mean, somebody who is from this diploma, he cannot become a tutor.
Yes. I'm coming to it. There's the second part.
Lordship has got it.
I'm coming to it. This case is regarding their fact of this case, my lord. Here the interpretation of the rule I am coming on, my lord.
No, I understood, no, but like this, I mean,
Yes.
this statement, I mean,
Yes.
I mean, because qualifications are different.
Yes. Yes, qualification differentiations here, my lord.
Hmm?
Yes, but this thing comes once a person is a graduation.
No, but now I'm asking like whether this statement is correct. However, once they merge into the cadre of staff nurse, candidates from both streams become eligible for promotion to the higher posts of ward sister, tutor, public health, so and so. But I mean, whether this can be termed as correct, because the persons who become staff nurses with the qualification of diploma, they are not eligible to become tutor.
Yes.
They are eligible to become only ward sister and PHN.
Public health nurses.
If I may just clarify, I'm not interrupting, I may just clarify your lordship to that extent.
Yes.
The staff nurse is the entry cadre
Hmm.
in the nursing, wherein the staff nurse have either to be graduate or diploma.
Correct.
Now, they are one cadre. Now, when they get promotion, the next promotional cadre is on the academic side and the clinical side. To be on the academic side, you have to be the BSc nurse or post-basic BSc.
We'll go to the rules and show these are, my lord.
And I'm just clarifying for your lordships as an assistant of this court. So they have to be BSc, either to be sister tutor or PHN. And to be on the clinical side, you have to be GNM. Now the BSc can also be on the clinical side. But to be on the academic side, you have to be specifically in the clinical side. And ANM is a feeder cadre than to staff nurse, your lordship. Because the pay scales
Here
will
I
determine.
object. It is direct recruitment post. I'll show. It's not a
Yes,
feeder
yes,
cadre.
I've just clarified.
I'll show from the rules.
Okay,
It's a
okay,
direct
okay.
recruitment post, my lord.
Okay, let's go ahead.
My lord. My lord. I'm in the.
It may be mentioned that.
It may be mentioned that while staff nurse who come from the stream of GNM can be promoted to the post of ward sister, which is essentially meant for services to be rendered in the hospital, in the clinical side. Those staff nurse who had entered into service, being graduate nurses, has the option to be promoted only in any of the three available.
That has been clarified now.
Option. This is a statement. The members of the petition association are holding the post of said cadre of public tutor, public health nurses tutor. A promotional exercise to the next higher cadre of assistant matron, assistant nursing, superintendent, deputy superintendent,
was carried on, and as per Rule 22 of the Rules 21, a common gradation list has to be prepared from the ward sister, tutor, public nurse, tutor, and present promotion has to be made to the 3 posts of assistant matron, assistant nursing superintendent, such and such. However, it appears that 2 gradation lists are prepared on the broad category of tutors, ward sisters. In the ensuing promotions made, all the posts are filled up by the candidates who are working as ward sister, and none of the members of the association who are working as tutor, public health nurses tutor have been considered for promotion. Reason behind the appears to be creation of 2 gradation lists and consideration of the candidates belong to the gradation list of ward sisters. Then paragraph, my lord, paragraph 7. Learned counsel for the referring to 91 rules, more specifically Rule 22 thereof, has submitted that condition precedent of having 1 gradation list has been admittedly violated, which is apparent from the pleaded case of the respondent department. By referring to the affidavit position 4 to 20 filed by the respondent number 4, which has been submitted that paragraph 19 thereof, there is a clear admission that 2 gradation lists were prepared. 1 gradation list consisting of the nurses personnel serving in the academic side, and the other consisting of the nursing personnel serving in the clinical admin side. It has further been submitted that pleadings in the affidavit in opposition were wholly inconsistent with the members of the promotion committee being such and such. It is submitted that through the minutes which is relevant in the present case pertaining to assistant nursing superintendent appears to be in order, the constitutional action taken to publish the impugned order such is not at all consistent with the said minutes, and rather same appears to be in accordance with the pleaded case of the respondent. It is submitted that when basis of the promotional exercise was not in accordance with the law, such constitutional action is liable to be interfered with. My
Yes.
then lordship may come to para 11. Para 11 is the main part. It is not with regard to having eligibility to be promoted to the next higher post of assistant matron, as assistant nursing superintendent, deputy nursing superintendent, but the principal conditions which were required to be followed before initiating such promotional exercise. That's what my case here. It is admitted that, in fact, the 2 gradation lists were prepared instead of as contemplated under Rule 22 of 91 rules. It is from the gradation list of ward sisters alone the candidates were considered and promoted to 71 numbers of vacancies in the said post. Such non-fulfillment of basic requirement has not only deprived the members of the association from a fair consideration, but appears to be an utter violation of the rules holding the field. In my case also, I will say, my lord, let there be a common gradation list. There the second instance come, whether we are entitled or not, the authorities will see. If we come with the general consideration, they'll consider our case. If not, throw them out. Let them be there. That's the Rule 22 is the paramount importance here. Next, my lord. My lord, lordship may come to 12. This court also find force in submission of Nayar counsel for the petitioner that minutes meeting dated is not consistent with the pleaded case of the respondent as found the affidavit position. While the notings made in the said minutes appear to be consonant with 91 rules, the action taken doesn't appear to be in terms of the said minutes, wherein a contrary view has been expressed in the affidavit position. Further, it is strange to note that while amendments in the affidavit position are based on the said minutes and essentially being the matter of records, those have been verified to be true to the knowledge of the such and such. No doubt, department was part of common promotion committee. Minutes being a part of the records, departments could not have been verified such and such. My lord. Para 13. In view of the aforesaid fact and circumstances, this court does not have any other option but to interfere with the impugned exercise, which had culminated in the impugned order dated 11/4/18. Accordingly, the entire promotional exercise pertaining to assistant matron, assistant nursing superintendent, deputy nursing superintendent undertaken on the basis of 2 gradation lists culminating in the order dated 11/4/18 is interfered with and set aside. Department may carry out fresh promotional exercise by strictly adhering to the provisions of 91 Act. At this stage, it is observed that since private respondents were beneficiary to the faulty promotional exercise and are serving in higher posts, no recovery should be made from them. The same direction will also be applicable to the private respondents who have rendered superannuation retired on superannuation in the meantime. A fresh promotional exercise may be carried out and completed with time-bound frame, preferably within 6 months from the date of receipt of certificate of this order. It is further observed that since there is a need for promotion to the higher post of assistant matron, assistant nursing, such and such, the fresh exercise of promotion will be given notional effect from the date of impugned order. That's what, my lord. The first thing is, my lord, if the rule provides you are to do certain things in a certain way, you must follow these rules. Then we come to the gradation list. Once the gradation is prepared, then there is a provision for consideration of for promotion under Rule 11, Rule 12, these things will come into force. First thing is Rule 22. Now, in the Nazir Ahmed case, it was recorded just now, my lord, in the justice of, just now I gave a judgment to Honorable this Court Justice Mehdi, my lord, about the association case. There, it has been quoted, my lord. It's been quoted, my lord. Kindly come to page number, that's in paragraph 20, page 10. Flag A, lordship, my lord, just now I have given. Para A. Para 20. This is not your lordship, my lord, because every time we come to the court, we submit this.
Para 20 years.
Para 20 years. When law prescribes a process for a particular action to be taken, that process cannot be bypassed. At this stage, it would be apt to refer and rely on the observations of this Honorable Privy Council in the landmark case of Nazir Ahmed versus King Emperor reported in 1936 PC, wherein the following observations are made. The rule which applies is a different and not less well-recognized rule. Namely, where a power is given to do certain things in a certain way, the things must be done in that way or not at all.
Yes,
The
yes.
other means of performance are unnecessary forbidden.
No, that's a subtle law, yes.
That is it. That's why I said, don't you lordships also.
Mm.
Now, lordship has seen the other day I have given two judgments. Ritesh Tewari. Ritesh Tewari, it says, if the initial action is bad, all subsequent action is bad. In next case, by Justice Koteshwar Singh, Ritesh Tewari I have given, my lord, the other day. Ritesh Tewari, 2010 4 SCC I have given the other day, my lord.
2010?
4 SCC, 2000, my lord. 2010 10 SCC. 2010 10 SCC.
2010 10 SCC.
Yes, 677. Actually, it's bad. Paragraph 25, 26. My lord. Paragraph 26.
Para 26.
Paragraph 26, 27, 28. Small paragraph. 26, 27, 28. Very small paragraphs. Only.
Flag mark even so even key now. 227. 2010 it has.
My lord, I got one extra copy.
No, we'll get it. Should be here if you have given.
Yeah, it is there. The other day I have read, my lord. Ritesh Tewari and another versus state of UP.
Yeah, Ritesh Tewari, yes.
Yes, lordship has got it, my lord.
Hmm.
Paragraph 26, my lord.
Para 26, yes.
Yes, 26, 27, 28. Let me read paragraph, page number 8, my lord. It is settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. A subsequent action, development cannot validate action.
No, that day also you have referred to.
Yes, that's what I'm saying. That's what I said.
Now, your basic case is what? What you are asking now?
I'm asking, my lord, if they followed Rule 22, they could have come up with one gradation list. Now, kindly see in the repetition of the gradation.
Now they have come up with two gradation list.
My lord, in the gradation list, our name is not even there. If we were following the cadre, lordship 3, 1 and 2, C.
No, you are not in the zone of consideration.
That is the second part. We are not even in the gradation list. Where from we will come in the gradation, my lord, zone of consideration? First, we should be in the gradation list, my lord. Then from the gradation, they will drop the candidates, my lord. We are not even included in the gradation list. That is what Rule 22 says. Common cadre, its name is not there at all. We filed the representations, my lord.
Show me the list. Which is the list?
Yes. Page number 28. It starts from page 27.
Yes.
on the basis of the objection for
So
rectification.
this is a common seniority list of
Ward
ward
sister,
sister,
ward in charge,
in-charge.
nursing sister,
Hmm.
OT sister,
Hmm.
sister tutor
Hmm.
of under the DHS,
Hmm.
DHSFW, DME, and kindly see PHN only under DHS service Assam.
So on your only thing problem is happening that PHN is there, but like your member from your association is not
Is
there.
not there. But the rule says the covered graduation list.
Hmm.
That is the basic condition, my lord.
And you are also a PHN.
Also in PHN, yes, PHN.
You are also a PHN.
PHN, yes.
But not under Department of Health Services.
Yes, because rule doesn't say that from the DHN only, DHS, there should be only in the rule says if they fall in the cadre, then rule 20 will be followed. Let them make a graduation list. Once I make the graduation list, then the question of promotion subsequent action comes, my lord.
No, so your case is that like though you are a PHN
Yes.
and PHN is part is
Cadre.
also covered by the rules.
Yes, 2I and 3.
2I and 3.
Yes.
So under 22, the rule 22
Common graduation
is
list.
common gradation list is supposed to be there.
Yes.
And in the common gradation list that they have prepared, all the persons are there, but but though you are a PHN, your name is not
From
there.
the family welfare department, we have followed the director of family welfare. It is not from there, my lord.
Director of Family Welfare, it's not there.
Nobody is there now. No, rule doesn't say. Where is the in the rule it is said? Rule says common graduation list.
And rule says service.
Service. That is the basic case. Now what happened? One question arises now. Lordship has seen the objection raised in the first page number 27.
What is the stand of the government on this?
I'm coming to it, my lord. Before that, let me clarify this point. Now, Lordship will find here what we have done. When the final graduation list filed, we have filed the representations. It is not like this. What happened? Initially, we filed a writ petition. And the writ petition, what the government has done, they have made a graduation list without any dates, nothing. And it is written there for objection. We knew nothing. Who is date what? They have cancelled their graduation list. When they have cancelled the graduation, made a new one, we withdraw that writ petition. We have challenged this one. In this petition, what they have done, in page number 27, kindly see, have a look at once. Just have a look, important. It's important.
Page 27.
Yes. They withdraw this one. In the affidavit is there, the earlier one. When he said there is no dates, nothing, how to file objection? Who is date, to whom, nothing is there. So page 27, see, on the basis of the objection claim for rectification of the provisional seniority list published on 3/1/25, this final graduation list of ward sister such and such has been prepared as on 5th January 25. My lord, in my paragraph 7, page 8, I have clearly stated.
Now tell me one thing, what can be the basis of that only under DHS Assam?
They will answer this one. Because
Correct.
in the rule, there is nothing. Rule says common graduation list, my lord.
So what is the answer in this, in the affidavit?
They basically, my lord, let me have a look at the affidavit, my lord. There is, my lord, something I couldn't even understand what is the answer, my lord.
No, that is your basic thing.
No, I'm not saying that. That answer they've given is a very clumsy answer. That's what I know.
So correct. So that is their basic case. So DHN, why only DHS? Why not this Family Welfare Department also?
In the paragraph, page 57 said, it is pertinent to mention here that in the affidavit.
Where
the graduation list, name
one second. Affidavit
of the government.
Government. One second. Page
57.
57. One second. Yes, page 57.
See the third paragraph, however.
It is pertinent to mention.
Now let me read from middle paragraph. Consequent upon, as per minutes of the meeting, the DHS Assam forwarded seniority list of PHN prepared this directorate DHS FW Assam by number such and such for onward necessary action.
So director of DHS FW is different.
Yes, 3 directorates. One is DME, Director of Medical Education, Director of Health Service, and Family Health and Welfare. That's one.
So you fall in
Health, FW, Family Health, Family Welfare. FW, Family and Health.
Okay, you fall in FW.
Yes, FW is called. See third paragraph.
Now
It
one
is
second.
pertinent to mention here that.
Just a minute.
My lord.
So 3 directors are, one is Director of Family Welfare. Now Director of
Health
DHS.
Service. One is the Health Service.
Director of Health Service. Health Service, Family Welfare.
one is family welfare,
Huh.
one is DME, Director of Medical Education. This is for admission purpose.
Now, these are all under Director of Health Services.
No, no, no. Three directorates they made under the
So,
Health Ministry.
so one, you are saying Director of Health Services,
One,
one.
Director of Family and Health Welfare.
Directorate of? Director
FW,
of?
Family and Welfare. Welfare. What is this
Director
called?
of Health Services within bracket family welfare.
Family Welfare.
No, no, one you said Director of Health Services.
Yes.
The Director of Health Services is what? FW?
Not, this is a separate one.
So one is Director of Health Services.
Yes.
And one is Director of Health Services FW.
FW, yes. And one is
one
DME.
second, one second, one second.
Right, Buddha, one is DME. Three. Right, Ayush.
Director of Health Services FW.
FW.
And number 3 is
DME, Director of Medical Education.
Director of Medical Education.
In my learned friends, there's another director is cropped up now.
So
Now he's saying, my lord, there's another directorate.
Director of Medical Education is DME.
DME.
Okay, and another one was?
No, he's saying, my lord, Master Ayush, it's a new Ayurvedic.
I mean, Director of Medical Education, whether any nurses are involved there?
No, this is for admission purpose.
Only education. So medical colleges, I mean,
They will have their nurses that will be appointed by the DME.
DME. So DME is a different, altogether different this thing. And Director of Health Services and Director of Health Family
Different. There are different.
Health Services FW.
Oh, my lord, Director of Health Services, my lord, there is a director.
Hmm.
And in the district, it is a joint director of health. But so far as the Director of Health Services, within bracket family welfare, it is the chief medical and health officer, grade 1, who is the head in the district.
Hmm.
They have,
But-
my lord, two different, my lord, separate, my lord, appointing authority.
But all these directorates, they follow, I mean, whether they are guided by this thing, this rule.
In the rules, nothing is mentioned in the rules.
Huh?
This is the rule.
Nursing rule is same.
Appointing of- They will have their own cadres, own vacancies. Not that, my lord, grade 4 employee, there is a common, my lord, say service rules. Doesn't mean that for the entire state of Assam, all these people, there will be one gradation. Every department, every district will have their own, my lord.
That is nowhere written in the service rules. Nowhere it is mentioned. This is the only service of nursing home you should see. Those who fall in the nursing home, we are in FW. Those who follow the FW, the moment they are PHN, it is not there. Now kindly see paragraph 3 of page 57.
Hmm?
Page 57.
Yes.
However, it is pertinent to mention here that in both the gradation lists, name of PHN belonging to the petitioner organization who have promoted from the post of ANM and LHS, LBS were not included as because respondent number 3 Assam awards promotion from post of PHN to DPHN, my lord. This is what meaning I didn't understand. That's why I said, my lord, this is very clumsy. One. Nowhere they say, no. There are three rules are, this is the rules. And these persons falls under different categories. Then paragraph 6 also kindly see page 58.
What is DPHN?
District PHN.
District Public Health Nurses.
District Public Health Nurses.
The next level, for which one, the entire, my lord, the district now. Educated by the government. One, my lord, you pointed out that, my lord, the gradation list, the final gradation list is our challenge in the present situation. Not a single, my lord, person in the gradation list is the party here. They want the crossing of that, but without they being party, will be the most affected party. Not a single, or even a representative capacity, they are not. How these honorable.
Who are there in the gradation list?
Yes.
Now they have been made.
But you have come,
No, your lordship, we are only 32 in numbers.
Hmm.
That submission I'll make.
PHN, public
There are
health
almost
nurses.
140 numbers of nurses. None of them has been implemented, your lordship.
that objection you have raised already.
Yes, your lordship.
There's the
Most affected.
And most importantly, I'll let my respect.
My lord.
Complete.
Now kindly come to page number 58, my lord, of this.
Yes.
With regard to the statements made in paragraph such, deponent begs to state that final seniority list in that calendar year could not be published due to some unavoidable reasons. as the seniority list valid in the particular year, calendar year. Therefore, provisional seniority list published on 18/12/24 may be treated as invalid. That one I said, my lord, that list they brought out that may invalid, and now they have made this one. Now let me see in paragraph 8. With regards to paragraph 6, deponent begs to state that deponent published a common seniority list of ward sister, ward OT, nurse, nursing sister under DHS, DHS, FW, DME, and PHN only under DHS Assam. That is what they say, my lord. Only under DHS. Paragraph 15.
So in the gradation list, total how many candidates were there? 140 something.
Public health nurses, my lord, 1, not much public, 1, 2, 3, 4, 5, 6, 6.
No, okay, I
Seven.
mean, okay, now thing is that, I mean, some of them have been represented
7.
by,
Entirely
some,
7.
some of them have been
323
represented.
numbers of members are there.
But some of them you are
32
representing.
Two are before this, your lordship.
Huh.
Others are not there before this honorable court. They have not added even a single person.
7 public health nurses are there. 7.
No, I mean, see, now you are challenging the whole, that's what I was looking into, the prayer.
My lord.
Prayer, yeah, what is your prayer?
To set aside the gradation list. In fact, I have taken that objection.
That I have seen now, so you want to like set aside this.
Yes.
But with, I mean, if the court comes to a conclusion that let the list be set aside, but whether court can do it?
No, I'm coming to it. I'm coming to it. Lordship, kindly see paragraph 1, page 15, our prayer. Setting aside and quashing the final seniority list of such and such, my lord, DHS Annexure 5. Then direct the respondent authorities to prepare a common gradation list for sister, including PHN, who are members of the association. And next one also direct the respondent authorities to make promotion on the basis of the additional final gradation, my lord. Now, lordship always can mold the relief, my lord. Lordship can always mold the relief. Now, see, these prayers are there. I can confine to the prayer, my lord, so far the public health nurses are concerned, including public health nurses I have written here, my lord. So lordship may not give me the full relief. Lordship may confine to public health nurses. Lordship always can mold relief. And always make a prayer end of first such a further orders, my lord. In paragraph 1, paragraph 2, Roman 2. Common gradation list, including PHN, who are members of the association, my lord. So para 1 in the prayer, lordship may confine to public health nurses. It's not necessary to go for the entire list. I may have a prayer, my lord, I may not praise everything, my lord. This is the lordship is always allowing us to do that.
But they will be affected, I mean, if there is some order is passed also.
No, so far the public health nurses are concerned. Lordship may confine to public health nurses.
Public health nurses
They have got
also,
impeded.
public health
They
nurses.
have got impeded now.
The public health nurses also,
Yes.
if somebody is, I mean, included in the gradation list,
Yes.
then their seniority will be hampered.
My lord, they have been included. My lord is representing them now. At the
No,
time of hearing this is now.
Some of them, but what about others?
No, in the entire list, there are 7 PHN only. There are only 7 PHN in the entire list, my lord.
Correct.
Yes.
But I mean, how many people are there in your association?
There are 14 now.
14.
14 now.
So 14.
Yes.
If any order is passed in your favor, hypothetically, then 14 has to be included there.
Not necessarily, because once I come in the graduation list.
No, that's what, if 14 people are included in the graduation list, then the seniority will be, go
Yes,
here and
but
there.
there are in the 7 persons only now.
No,
The
whatever,
government
I
will
mean,
take action. If we are entitled, government will see, they will say that suppose there is no vacant post, there will be vacant post. They up to their domain that is. Subsequent they'll do. That situation has not come up today. Today's situation is rule 22 provides.
no, thing is that if any effective order has to be passed, see, there is no point passing any order, correct? So you'll have to pass an effective order. Now, if any order is passed, whether the parties who are not there, not here before this court will be affected or not. That is the first question we'll have to see.
If your lordship
Now,
said,
if your writ petition is allowed, and other parties who are not before this court are affected, then how can this court will pass the such kind of order?
My lord, at least lordship kindly implement petition. How many of them have been implemented now? Large number, I think. Quite how many numbers?
32.
32 public health nurses have been
Only
implemented here. my lord.
1/10 of the
All of them, my lord. In the selectees, there are only 7. We are 14. Now, if they follow Rule 22, we come in the graduation list, my lord. The main thing is on Rule 22, my lord. That is subsequent action, my lord. Now, he has got implemented. There are 32 now. We are 14.
Okay.
If they follow Rule 22, if they don't promote me also, there's a different cause of action for that, my lord. At least for rule, that's the reason the single judge, the judgment I have annexed here, my lord. By not following Rule 22, they promoted a large number of persons, my lord. They have been brought down, my lord, by setting aside their promotion order, my lord. This, the single judge said first for Rule 22. In the inception, it is bad, so subsequent action. Luckily, the salary was not deducted. That's a different issue, my lord. My basic contention is, if the rule provides, nursing rule provides, we are also nurses. We got promoted from one post to another post and then this one. Now, if you do not include us in the graduation list by following Rule 22, what's the consequences? Consequence will be just like lordship has passed the order, the page 49, the single judges brought down all this, my lord. They said follow Rule 22, my lord. That's the basic condition. Subsequent action is bad. If initial action is bad, all subsequent action is bad. Detest the worry. This is my case.
Okay.
Now, my lord, in this respect, my lord, we have submitted representations. Kindly have a look at this representation, my lord. There's in page 40, 25/9/25. After the seniority list came to our knowledge, my lord, we filed this. The entire fact we have written here, my lord. Till today, this has been disposed of. And only then it came before the court, my lord. And before that, also we filed our representation. This issue of non-inclusion representation dated 25/9/25.
Yes.
My lord, the entire fact narrated here. Can you see the paragraph, prayer in page number 42?
Yes.
Hence, under the aforesaid fact and circumstances, more particularly in view of Rule 22 of the Assam Nursing Service Rule 91, we would like to pray that before your honor to cancel the aforesaid final graduation list dated such and such and to prepare a fresh final graduation list of the ward sister such and such and PHN, including names of the public health nurses belonging to our organization who have been promoted from the post of ANM such and such. Here they've included the place of others. At least the respondent ought to get disposed of, could have said to, yes, you are not entitled. We don't even know, my lord. From the affidavit, it is not clear. About the rules we've stated here, my lord, Rule 22. Paragraph 4 is very clear. We made statement about the Rule 22.
You got it, got it. I mean, your representation is not disposed. There is
Not at all disposed of, my lord. But lordship can do one thing, my lord.
So your only case is that, I mean, because Rule 222 says that all services should be included. You are also part of the services.
Yes, yes.
So as per Rule 22, one gradation list should have been published. And in this case, I mean, though gradation list has been published, your services has not been included.
My lord, I'm obliged, my lordship, exactly got my point.
That is the thing you can.
That is the basic contention, my lord. That's why my subsequent judgments I have given is, this initial action is bad, the subsequent actions are bad, my lord. That's the reason I have given those to my lord. Suppose I come in the list, graduation list, my lord, then they will consider my case promotion. They will try to find out whether I fall within the zone of consideration. If they find I don't do qualification of the nursing rules.
Okay, I got your point. I got your point,
Yes,
Mr.
my
Nag.
lord, that's what.
I understood. If there is there anything else?
That's my case, my lord.
Okay, Mr. Gogoi needs to clarify.
What's the name?
Lord, so we will kindly have a look at page 27, the order impugned in the present petition.
Page 27, yes,
Yes.
page 27.
The, my lord, final gradation list, my lord.
Yes.
It says, my lord, on the basis of objection claim for rectification on the provisional common seniority list published on 3/1/2025, this final common seniority list of ward sister, ward in charge, nursing sister, OT sister, sister, tutor under DSS, DSS family welfare, DME, and PSN only under DSS Assam. So,
No, that
my lord,
then-
rest of the cadres, it's common for all the directorates, my lord.
No, yeah, sir,
Only PSN, it is, lordship will.
No, you are saying that
Yes.
this final common seniority list of
For the,
wards,
for the
so and
post
so,
of
so and
ward
so?
sister, ward in charge, nursing sister, OT sister, sister tutor under DSS, comma, DSS family welfare and DME.
So this, I mean, all these are
Yes,
common.
these are common
Hmm.
except PSN and PSN within bracket only under DSS.
So why is this so?
Yes. That part lordship will see.
Hmm.
In an affidavit, we have stated
Hmm.
that the appointing authorities are different, my lord.
Affidavit, yes,
Yes, my lordship will
page
see.
56. No.
Page 56.
Hmm.
Running page 56, para 5.
Para 5. Yes.
Says, my lord, that the deponent begs to state that two numbers of provisional seniority list was, it was earlier time.
Hmm.
Stated two numbers of provisional seniority list was published. One of the ward sister, ward in charge, OT nurse, nursing sister, which are equivalent post in nature, and other for the post of sister tutor, PHN, by the office, letter dated 18/12/2024. This is a provisional seniority list, my lord.
Earlier it was, I
Yes.
mean.
Eventually, the post of PHN are created under the establishment of Director of Health Services Assam and Director of Health Services Family Welfare Assam, and by virtue, both are the appointing authorities.
Hmm.
It is pertinent to mention here that initially the post of ANM is an entry level post. After serving in the post of ANM and undergoing special training, the incumbents serving in the post of ANMs are promoted to the post of lady health sister and LHV.
Hmm.
Lady health visitors. Thereafter, on completion of the required period of service in the cadre of LHS, LSB, and after obtaining 1 year of diploma, the incumbents are promoted to the post of PSN.
Hmm.
Now, my lord, this minutes is important, my lord. As per minutes of the meeting dated 16/12/2024, contained in point number 9, decision was taken that from the existing vacant post of PSN under DSS Family Welfare, where the petitioners work, Assam, 30% of the post shall be filled up by way of promotion from the cadre of staff nurse, having BSc nursing, post basic BSc nursing, who are under DSS Assam and DME Assam, and remaining 70% of the post shall be filled up from the cadre of LSB, who have completed PSN diploma course under DSS Family Welfare Assam. So, my lord, the posts were segregated. 30% under DSS, 70% remains with family welfare.
It has been done by way of minutes.
By way of minutes.
And that has been put to challenge.
It has not been put to challenge.
No, that is challenge. And there is a stay operating.
Then,
The petitioners have got themselves implemented, and this fact has not been disclosed.
accordingly, the DSS Assam will share the details of the seniority gradation list, ACRs, etc. of eligible incumbents of DSS Family Welfare Assam. Consequent upon, as per minutes of the meeting, the DSS Assam forwarded the seniority list of PSN prepared by this directorate to the DSS Family Welfare Assam by letter dated so and so for onward necessary action. However, it is pertinent to mention in that in both the gradation list, the name of PSN belonging to the petitioner organization who have been promoted from the post of ANM or lady health visitor were not included as because the respondent number 3, that is DSS Family Welfare Assam, awards promotion to the post of PSN to DPSN.
What does it mean?
My lord, that 70% post, my lord,
Hmm.
those posts will be filled up by way of a promotion issued by the Director of Health Services Family Welfare.
That part is no problem, my.
Let me complete. Lordship will kindly mark this 30% by DSS, 70% by DSS Family Welfare. Now, since this particular gradation list, my lord, has been published by the DSS, so, my lord, whoever comes under the DSS, only the names of those persons, my lord, they figure in the, my lord, gradation list. He can, my lord, publish the gradation list of his own employees. He cannot, my lord, publish the gradation list of some other authorities, my lord, who is to appoint them, my lord. That is the family welfare. And Lordship will see, my lord, these appointments which have been made by the DSS, various staff nurses and all have been posted in various places, including the medical colleges. Lordship will see that clarification, Lordship will see. Page 28 again, just my lord for a moment.
Yes.
Lordship will just see my lord, the name of the institution. Red column. Joint DSS Kasar, then joint DSS, now serial numbers 5 onwards. Silchar Medical College, 6 Assam Medical College, 7 Borpeta. Next is Nalbari, GMC, Gauhati. So, my lord, they are posted, my lord, in various medical colleges as well as the civil hospitals. But the appointing authority is, my lord, DSS. So, since this particular gradation list has been published by the DSS, Director of Health Services, so only those persons who have been employed by him, my lord, their names figure in this particular gradation list. Now, my lord, this was published.
For them, there will be different gradation list.
Yes, my lord, it will be by the FW.
It will be by the DHS FW.
Yes. That's why, my lord, they say that, my lord, it has been published by the DSS. That's what is there in the affidavit, my lord. Now, if they had any grievance, they ought to have raised it, my lord, at the very threshold when the provisional gradation list was published. They choose to remain silent. They not even hesitated. Now, after the gradation list has been finalized, this writ petition has been preferred.
So now, are you representing FW also?
Yes, but affidavit perhaps has not been filed. I've asked my colleague, my lord, they say that, my lord.
So then the stand of FW will
Yeah, it will be very vital. Why it has not been published on their part also. Had that been published, my lord, maybe 2 also, their name would have been there for those 70% post.
So see, I mean, now he is saying that like your grievance should have been before the DHS FW, because DHS FW is not filing. The DHS FW is not. Publishing the gradation list. He is saying that like these are my appointees, so I can publish a gradation list. But your appointment is somewhere else. And how can I publish the gradation list?
My
This
lord,
is submission.
I'm answering this one. I'm answering this one. Now in the nursing rules,
the service is same that I have seen.
Service is same for all these cadre, all these the directorate, right? If that is so, Rule 20 says, common gradation, let them show one rule which says these service rules. I can say this much, my lord. Let them show, this is the rules to provide that. For director health service, one gradation list. For them, another gradation list. For FW, another gradation list. From one rule, let me show, my lord. If they can show, Lordship may dismiss my case, my lord. Because Rule 20 so doesn't say so. This rule is applicable for 3 of the nurses, directorate, my lord. Then how can they distinguish this one? It's a question of rule, interpretation of rules, my lord. It's not filing an affidavit by an officer. He has to follow the rules. Rule is the same for everybody. See the Rule 22. All members of service. So Lordship may direct them, my lord, on which rule, let them file an affidavit. Now, which rule, which says there should be 3 gradation list under the nursing home, for which rules? Excellent, yes.
Mr. Gogoi, FW should file an affidavit.
Yes, but it will have to be clarified. That's what I was asking my colleague, that why it has not been filed.
The apparent,
they will have to say why they have not published.
On the face of it, it looks like that service includes all nurses. Correct.
Yes, my lord, since the judgment is there, my lord, it has not been put to challenge. I won't say otherwise, my lord. This is a common rule. For all nursing settings.
For all nurses.
Now, my lord, if they are separate directors, they are just separate appointing authorities. All their promotions, transfers are looked into by a particular directorate. So, my lord, how can there be a common gradation list? They will maintain their own gradation list. The rule will be applicable for each directorate, for their own staff. Whoever has been appointed by the
So
DMP,
now you were saying that, but how can these three directors will have a
now
common
who will
list?
publish the final
This,
gradation list?
this, my lord, the gradation list for two departments, can we see?
No, that's why I'm saying, my lord,
FW and DME.
who will publish
DME, they have
the,
included two. In common gradation, two, not FW. See, contradicted his own statement.
no, that's why I'm saying, no,
Paragraph 28.
I'm just pointing out, that
Paragraph
who
28.
will publish the final gradation list of all the three directors? Whose authority, my lord? Either it will have to be by the government in that case.
But in the case decided by the coordinate,
That's why I'm saying, my lord, that was not put to challenge. Probably that should have been clarified. This is a common rule. It will have to be followed by the DME. It will have to be followed by the DHS. It will have to be followed by the FW. They will have their own separate, my lord, gradation list. In fact, my lord, for grade 4 promotion to the grade 3 also, there is a common, my lord, service rule that is followed. They have no, my lord, separate rules. So that also rule says, my lord, all cadres. Cadres means, my lord, within the directorate. It cannot be from the FW.
That already is very important.
No, there are some practical problems
Yes,
because
practical problem, my lord. That was not pointed out.
other day also probably I was pointing out to Mr. Sinha that I mean if somebody somebody's there are certain posts in the tutorial side
Yes.
and there are 30 posts of tutorial in the tutorial side, and in the same gradation list the people who are actually qualified for the tutorial post they are in the bottom. Then how the post will be filled up?
Yes, sir.
My lord.
Your lordship, in the case which my respected senior has referred to, 3069, I was the petitioner in that case. Your lordship, that case relates to the staff nurses, that is between the GNM and the graduate nurses.
Yes.
The ANM was no way involved in it, and the judgment does not say anyway that the ANM has to be included. It says that one common gradation list between the two sets of employees who are similarly situated. Now GNM as well as staff nurse, they are both, GNM as well as graduate nurse, they are both staff nurses. They have been promoted on the academic side, clinical side. There has to be one common gradation list. So it was in context to that reference, your lordship. Whereas ANM is a direct entry cadre, just like staff nurse, but ANM is a certificate course. Their grade pay is lesser than the staff nurse, be it GNM or graduate nurses. That I'll demonstrate, your lordship.
No, that I have seen.
No, my lord, kindly.
Facts have not been
Let me
placed in
finish
a
this
proper
one. Please
perspective,
come
your
to page
lordship.
27 once. Please come.
I
For my
will
sake.
cover the entire.
Please come to page 27 once. If each director of a directorate prepares a separate list, kindly see who has passed this order.
That's why I'm saying.
Director of Health Service Assam.
How the director only.
DHS. Come to the next page 28.
That's what I'm saying, that DHS, FW is also there, DHF, DME also there.
Yes.
So,
And PHN only this.
For DSS, madam, because that's 30%, 70% probably. So that affidavit from the DSS family welfare will have to be there. Why it has been omitted? Why they have not forwarded the names, my lord, to the Director of Health Services?
Lordship may add one line when, if your lordship grants them time to file affidavit, one line. Under which rule, my lord? One line. That will solve the entire issue. If they can show, I'm out.
Otherwise also, my lord, without the
Under which provision?
parties being party in the writ petition.
There's a
This,
different
my
issue.
lord, no, that's the main issue.
This is
That's the main issue.
question.
We may argue for, my lord, 2 days, 3 days, but finally, my lord, whether this honorable court can interfere, my lord, without those affected persons being party in the writ proceeding, my lord.
This is a legal question, my lord. Interpretation of the rules.
Legal question, but what is the effect?
Those are subsequent.
Tomorrow they will come in with one plea that, my lord, without making party, my lord, this issue has been decided and they are out from the list now.
That is also a relevant question,
Yes,
Mr.
madam.
That I have been also asking.
Ultimately, tomorrow the lordship's order will be questioned, my lord, on that point.
Now I'll confine my
No,
plan to
see,
PHN.
yesterday night also when I was looking into the matter,
My lord.
that question came to my mind because what happened to these other people?
My lord, I'll
And
confine to
before
my.
I said, they have already pointed out, and Mr. Sinha was, saying that his,
So
initial
I'll
objections.
shorten my prayer. I'll confine to PHN, and there the parties for the honorable court. There are 32. We are 14. I'll shorten my prayer. And lordship always grants I can mold the relief. And I
That
cut
can
down
be
my
done,
panels.
that can be done, that's
Yes,
a
my lord,
different
that's
thing.
right. But once
The
this
molding
issue
can
is
be
solved,
done,
my lord,
but
once this issue is solved, I think the number of cases will come down because they also know very well the rules made by them, my lord. It's a mess, my lord. When I talk to them, my lord, it's a mess. They has to come up with a proper rules, my lord, for those persons, my lord. Nothing is clear in the rules. Every time they also facing the difficult to answer to the court, we also finding it difficult, my lord.
no, anybody else is appearing for Director of Health Services?
No, I will.
No, no, FW?
No, I can appeal.
So, I mean, you file an affidavit.
Yeah,
then.
I will file my affidavit. At least on that point, my lord, why their names have not been incorporated.
Why their names have not been, and on basis of what?
Yes. Why?
That's
on
under
basis
which
of
rules,
what?
my lord? That's what, my
No,
lord.
not on the
Please.
rule, my lord, why they have been left.
Rule is important.
That's the main thing.
Why they have been, I mean, while saying that, like, why they have been left out, you'll have to back by something.
Yes, yes.
So you'll have to point out that, like, as per this,
Legal
like, this is
backing.
not.
My lord.
Hmm?
If they are
When can you file
contemplating
it?
to- My lord, immediately after vacation, my lord.
But you file it, but otherwise, I mean, Mr. Sinha, otherwise it will be difficult for this court to adjudicate the matter.
Your lordship, I leave it to your lordship, but
But that's a relevant thing.
No,
See, I
lordship will
mean,
keep it part
see,
out, my lord. Lordship will
see,
fix it
the-
immediately.
Lordship is part of my lord, yes,
Only
yes,
at
that's
that
make
point,
it
my
part
lord,
of.
it will be
the
clarified.
list has been published, one list has been published,
Right, your lordship.
and a particular group of people has been excluded, specifically stating there.
They cannot be in that list. That
No,
is the
correct,
state.
why it cannot be,
That's
court,
what, that's my submission.
no, wait. Why they cannot be, I mean, we need to hear not from the private parties. We need to hear it from the
Exactly.
authority, why they have left out those people, not from you. So, so to that extent, we'll need to have some material before this.
I exactly bow down to your lordship, what is the lordship has said.
Mhm.
But there are also facts which needs to be adjudicated.
That you
Therefore,
do,
Your lordship,
that you'll be allowed.
from I have annexed everything, a bare perusal of this, and if your lordships allow me to make my
No, no.
submission,
No,
which
no.
I'll take half an hour, I'll demonstrate that they are only certificate course holders. They
I
are
have-
not eligible to be in this list, your lordship. The law will prevail, your
Yeah,
lordship.
correct, but like authorities should answer first thing. See, before hearing you, also, that I mean, any court,
Yes, your
when they see the accreditation list, they will ask a question. Why? I mean, if all this, I mean, nursing services are under this DHS, and this nursing rule is applicable to all, why those people have been left out?
Because they don't fall in our cadre.
Correct. That is a pertinent question.
Yes, your
And that
lordship.
question will be answered by whom? By the authority.
Yes.
No,
Yes, your lordship, absolutely
you
right.
can
your
bring in those facts, but let I mean, the court will hear.
One
from
more
them.
important thing, your lordship, I'll just clarify, leave everything up to your lordship. I'll reserve my right to make my submission. your
You will
lordship.
do it.
Who are the ANMs and how these ANMs comes into the picture? There is an ANM course which has been structured by the
But
Indian.
but you are utilizing A&M services or not? Their nurses are not.
No, what I'm trying to say is
They are, no, see, their qualification, entry, those things are there.
right, your lordship.
But now they are into the nursing services.
Yes, your lordship.
If nursing services rule is one, correct? Then why they are not covered under this rule? If the services are, now Mr. Gogoi is saying that, like, since there are different directorates, it's a complicated issue. It becomes difficult to make a consolidated one this thing, but they are doing it. Now that has to be clarified why they have
Your
left out
lordship,
this paper.
yes, sir, your lordship is correct, your lordship. The nursing services consisted of various cadres. Every cadre has to be for every cadre, there has to be a different gradation list. The ANMs, what they are trying to say, that they don't want to be in their gradation list. They want to become.
Tell me one thing, in DME, whether A&M nurses are working or not?
Your lordship, ANM nurses are basically, they are working in the block level. They are not working in the mainframe. The purpose of the ANM is to render the services for the female healthcare in the villages, like immunization. Now, giving the details of the programs, what new medicines are coming, and basically they function to take care of the female health,
Correct.
persons.
They do that in the entry level, right?
Yes.
Now after that they qualify.
Yeah.
After some service they qualify. They qualify to a different level.
LHV.
Correct.
Yes.
Then they become PHN.
No, they cannot be PHN. They can become a PHN at the block level, that is at the village level only. Your lordship will kindly
So
appreciate. the fact-
PHN also has different
Yes,
categories.
PHN at the block level and PHN tutor.
But
No, the rules, my respected senior has not read everything in its entirety. Your lordship, I'll place everything in entirety. Something may be against me.
okay, let them
something-
file an affidavit.
Yes, your lordship.
Let them file an affidavit.
Your lordship will kindly protect me to the extent that I'll reserve my right to make a submission. on-
Yeah, heard Mr. M. Nath, the learned counsel, learned senior counsel, assisted by so-and-so. Also heard Mr. B. Gogoi, the learned additional advocate general, appearing for respondent number.
All state respond.
For the health department, for all the respondents in the health department, full stop. Also heard, then Mr. R. Singha for the private respondents. Private respondents. After hearing the matter substantially, this court is of the view that an affidavit from respondent number 3. Affidavit from respondent number 3, that is the Director of Health Services in bracket FW, Assam. Assam will be required for proper adjudication of the matter as it has been seen from the impugned gradation list, right? Impugned gradation list that that PHN walking in the PHN walking in the DHS in bracket FW have been excluded from the gradation list. Full stop. Full stop. So therefore, the respondent number 3 will clarify as to why and on what basis the PHN of DHS FW were excluded from the gradation list.
In fact, your lordship, if I may kindly submit, the very promotion to the cadre of PHN and the subsequent action of that 70% and 30% what my friend has submitted is under challenge, and the honorable court has stayed it.
Let them clarify.
Yes, sir.
Mr. Gogoi, you clarify all these things. Huh? Bring in a detailed thing.
Yes, yes.
See, this court is not very much, accustomed to very service laws. So you bring in a lot of things so that you can assist this court,
No, I will place everything.
correct?
Yes, sir.
So I'll get some assistance, then probably I will be able to give justice.
But your lordship, the law will be settled once everything.
Yes. It goes against me on my favor, immaterial, my lord. Once the law is settled, my lord,
And that's what I'm saying. I'm fine with settling the law provided I get proper assistance.
There should be clarity, my lord, from both.
So matter is kept part heard, and the same will be listed on.
5th of May, my lord, if not inconvenient.
Let us keep the first week, will not keep it.
Lordship.
Okay. And the 5th of May, we can keep it. 5th of May. Okay. Let the matter be fixed.
Let me file the affidavit little early so that I can go through it.
My lord, I will.
If I let affidavit, so that.
But I can tell lordships one thing, my lord. It's a great pleasure to argue the matter with lordship. Since morning and all these days I'm seeing, my lord, I find really it's a pleasure, my lord. Your lordships, my lord. I'll be really very happy, my lord. We can place without fear and favor.
We try to give, whatever opportunities and whatever hearing is required. That's what.
Right.
That is our humble try.
God bless.